Proclamation of Claim and Interest. Table of Contents. Part 1. Proclamation of Claim and Interest of the Republic for the United States of America done at Ozark, Alabama, April 30, 2012. Exhibit 1, Declaration of Sovereign Intent adopted November 14, 2010, done at Windwalker Guest Ranch, Utah. Exhibit 2, Declaration of Sovereignty for the Republic of the United States of America July 20, 2010. 2a. The Declaration of Independence. 2b. Constitution for the United States of America. C. The Bill of Rights. Exhibit 3, Joint Resolution 20,110,202-4 Flag Act of 2011. Exhibit 4, 41st Congress. Sess. 3. Ch. 61, 62. 1871. Chap. 62 An Act to provide a government for the District of Columbia. February 21, 1871. Exhibit 5, The Atlantic Charter. August 14, 1941. Part 2. The States. The States represented for the creation and adoption of the Declaration of Sovereign Intent, Exhibit 1, above, Proclamation of Claim and Interest of the Republic for the United States of America. Done at Ozark, Alabama on the 30th day of April, in the year of our Lord 2012. Proclaimed by we the people on the Republic for the presented to United States of America. United States of America Joint Chiefs of Staff, the International Court of Justice, the Universal Postal Union, UPU, the United Nations, UN. Plenipotentiaries, James Timothy Turner, President James Buchanan Geiger, President Pro Tempore Mark Wayne Lounsbury, Speaker of the House Nathan Joel Peachy, Chief Justice, 1 Supreme Court. From and by limited sovereign authority delegated by we the people on the Republic for the United States of America. To the United States of America, Department of Defense, Joint Chiefs of Staff, and to the world, and all peoples, and all public and private persons, and United States, the Municipal Corporation, and all subsidiaries thereof, and the International Court of Justice at The Hague, and the United Nations, and the Universal Postal Union, UPU, and we the people, in God we trust, present and hereby serve notice of claim and interest, and continue in peace, and offer conditional forgiveness, and whereas, we the people proclaim, order, hold, continue, honor, and abide by the Declaration of Sovereign Intent, see Exhibit 1, instituted by presentment on behalf of we the people, and whereas, we the people presented the Declaration of Sovereignty for the Republic of the United States of America, c. July 2010, see Exhibit 2, to the following, the Committee of 300, the International Court of Justice, the United Nations, UN, and the Universal Postal Union, UPU, and we the people, claim all rights and uses, pursuant to Flag Act circa 1777, Flag Act circa 1794, Flag Act 1818C, and Flag Act circa 2011, see Exhibit 3, and we the people, claim all rights and uses, pursuant to Seal Act circa 1782, including the de jure United States of America Great Seal, and we the people, claim all rights and uses for the phrases, words, and letter combinations, the Republic of the United States, the Republic of the United States, the Republic for the United States, Republic for the United States, Republic for the United States, Republic of the United States, Republic of the United States, the United States, United States, the Republic of the United States of America, the Republic of the United States of America, the Republic for the United States of America, Republic for the United States of America, Republic for the United States of America, Republic of the United States of America, Republic of the United States of America, the United States of America, United States of America, and as referenced in the Constitution of the United States of America circa 1789, Exhibit 2b, the United States of America as alternate forms and denote Republic for the United States of America, and all deviations and variations thereof, and we the people, reserve all rights and uses for the abbreviations, phrases, words, and letter combinations. USA, US, ULS, USA, RUSA, USA, RUSA, RFUSA, RUSA, RAUSA, RFUSA, US, RUS and RUS to be abbreviated forms and denote the Republic for the United States of America, and all deviations and variations thereof, and with respect to Article 1 of the Treaty of Amity, Commerce, and Navigation, hereinafter referred to as the Jay Treaty, signed at London, November 19, 1794, ratified June 24, 1795, at Philadelphia, and now comes, we the people giving sufficient notice affirming, claiming, accepting, adopting and asserting that. Whereas, we the people are all created equal, and whereas, we the people, by natural birthright, with sovereign rights held by indigenous power live in inherent freedom granted by the Almighty Creator, by divine providence, and whereas, we the people are the named successor parties in interest, and as rightful heirs to the Constitution, circa 1791, with lawful right of claim for the Republic for the United States of America, have re-inhabited the de jure government, which was abandoned under duress and replaced by officers and employees of the United States Municipal Corporation, all subsidiaries thereof, et al., and all others committing such fraud, usurping the sovereignty of the people by fraud and deception. And whereas, we the people recognize the absolute right of people to contract with the United States Municipal Corporation and its subsidiaries, and whereas, we the people stand in agreement on Chapter X of, an Act to provide governance for District of Columbia, Exhibit 4, dated February 21, 1871, which states in part may contract and be contracted with, and whereas, we the people hold absolute unlimited right to contract and not to contract with any corporation, we hold and determine that the United States Municipal Corporation abused the letter of the law and the founders of the United States Municipal Corporation acted and contracted with ill intent by not giving full disclosure to we the people, and whereas, we the people hold, the founders of the United States Municipal Corporation deceived us into involuntary servitude as corporate subjects without us knowingly and willingly giving consent, according to law. Consent of we the people is required before elected officials of the United States Municipal Corporation may act, and whereas, we the people hold, contract by deception is not contract, and is contrary to law. No law shall be passed impairing obligation of contracts as guaranteed by Article 1, Section 10, in the Constitution of the United States of America, circa 1791, and whereas, we the people hold, there is no one with sufficient standing, authority, or ability to counter-memorialize, abrogate, or rebut our documented evidence and these self-evident truths, and whereas, we the people, as a paramount party to the Treaty of Ghent, circa 1814, provide notice of our original jurisdiction and of our capacity as sovereigns over any trespassing foreign municipal corporations such as the United States, et al., or their agents, employees, representatives, officials or contractors, A to Z, 1 to 301 etc., and whereas, we the people hereby hold, claim, enforce, continue, take, and accept respective jurisdictions on the land within metes and bounds of said Union and lawful authority thereof to self-determination by accepting responsibility for all Republic acts and actions, and whereas, upon lawful proof of valid claim by any party, the Republic for the United States of America will negotiate said claim with the claimant since it is in the best interest of we the people to satisfy our lawful obligations in comity and mutual peace with all nations, and whereas, with respect to Article 1 of the Jay Treaty, the Jay Treaty limits any person including corporations and other subdivisions of the Crown to inferior position with respect to we the people and we the people affirmed by Overture Dictum UN Charter circa 1950, continuous and in full force and effect, limiting and preventing state parties from using treaties or other instruments to increase their control over domestic citizens, and whereas, the unanimous Declaration of the 13 United States of America, Exhibit 2A, circa 1776, was served on the King of Great Britain by our founding fathers declaring our separation from governance by tyranny, and this declaration maintains that we the people continue certain unalienable rights granted by the Almighty Creator, by divine providence, and some of these certain rights were documented by the Bill of Rights, Exhibit 2C, circa 1791, being part of our founding documents and accumulated legacy of the people of America, and we the people are specific designated parties in interest, successors, and beneficiaries of said Bill of Rights, contract, expressly and explicitly reserving certain rights and imposing certain limitations upon the delegated government of we the people, and whereas, the founders of the Constitution, circa 1789, ordained, established, and included the Bill of Rights in the Constitution, circa 1791, and established absolute limits for governance delegated by we the people, the Bill of Rights invoked and affirmed by written record some natural, certain rights the Almighty Creator originally granted, being absolute, natural, unalienable inherent rights belonging to we the people, The Bill of Rights was not complete in enumerating said rights but was inclusive. The Bill of Rights can never be abrogated, infringed, denied, altered, abridged, or compromised by any governance or by any others, and natural rights are unalienable by any means, and whereas, by a constitutionally unlawful act of Congress on February 21, 1871, the territory of the seat of government, of the original de jure republic within the District of Columbia was incorporated with the District of Columbia, forming a new municipal U.S. government corporation operating upon the American people as a democratic, executively administrated municipal corporate government, and whereas, all de jure executive officers of the United States of America are required to take an oath to support the Constitution and an oath of office which places them under constitutional executive authority. Conversely, members of Congress are required to take only an oath to support the Constitution. Members of Congress are prohibited from holding any civil office and are constitutionally identified only as members of Congress known as the Senate Chamber and the House Chamber, lawful representatives of the sovereign people of the United States of America. After the assassination of President Lincoln in 1865, the Senate and House began taking a civil oath, Exhibit 6, of office, and after February 21, 1871, they changed the name of the Senate Chamber to U.S. Senate to accommodate for the change from a de jure republic Congress to the new U.S. corporation government, mandating that all members of Congress take the new civil oath of office, thus becoming de facto Congress officers of the U.S. corporation in an executive branch administrative capacity, no longer lawful members of Congress and no longer representing the American people pursuant to the Constitution, which is the supreme law of the land, and whereas, this new form of governance unlawfully imposed a foreign legal system, which is in opposition to the people of America and our law form, and the Municipal Corporate Congress replaced the Constitution, circa 1791, articles with amendments using Roman numerals, without full knowledge and consent of we the people and without authorization in accord with basic fundamental law, and their foreign decree legal system by fraud imposed non-injury prosecution upon we the people without sufficient full disclosure required by law, and whereas, said foreign decree legal system was imposed by deceptive acts and practices, indicating ill-intent governance by United States municipal corporation actors in mall governance, and Congress and other government organs and offices by valid circa 1791 Constitution were abandoned under duress since Reconstruction Acts, circa 1867, and whereas, the United States Municipal Corporate Congress circa 1913 imposed the unlawful Federal Reserve Act upon we the people. This invasion and trespass by commerce fraud by so-called public officials was committed against we the people without our knowledge or consent, and local free people were forced into involuntary servitude and poverty as a result of unlawful acts, commercial crimes, and all crimes inclusive. 27 CFR 72.11, contrary to our law form, and in direct violation and trespass of oaths of office and fiduciary duties by public officials working within their United States municipal corporation, and we the people hold this as a conspiracy contrived by the international banking cartel and bad actors within the United States Municipal Corporate Congress, and whereas, the United States Municipal Corporation circa 1916, in collusion and conspiracy with the Federal Reserve, did in fact, by act of fraud, impose unapportioned direct tax in the form of an income tax upon the labor of we the people, and this unlawful tax is currently being assessed, charged, and collected against millions of free people in America without lawful consent as required by existing laws, treaties and constitutions A to Z, 1 to 301, Judges 7, by cause of foreign decrees, non-legislated codes, statutes, and agency regulations. Many millions of people have been accused, and imprisoned by non-injury prosecution, in direct tort and trespass against our law form, and against our consent, against we the people, and whereas, the Municipal Corporate Congress circa 1948 unlawfully imposed Title 18 of United States Code as the code for criminal prosecution. Millions of unsuspecting people have been kidnapped, unlawfully arrested, prosecuted, and imprisoned for non-injurious crimes. United States Municipal Corporation and the Municipal Corporate Congress continues without lawful or legal authority to prosecute we the people as fictitious persons, using codes, statutes and regulations imposed without our consent. The agents and principals of the United States Municipal Corporation have committed egregious and horrific crimes against we the people, acting with full knowledge and intent to inflict undue harm on we the American people, and whereas, pursuant to the Jay Treaty and attachments, claims, show cause, points and authorities, we the people proclaim that we are the rightful established heirs, by birthright, to the United States of America. We the people on the Republic for the United States of America continue vested, established, interest and standing, being we the people of the Almighty Creator, by divine providence, who by order of the Almighty Creator have lawful standing and right of claim to dominion over this land, we hereby claim and exercise that divine right, and whereas, we the people hold that the intent of the Constitution and Treaty founders, circa 1794, laid a firm foundation and delivered the party-state crown and its subdivisions unto justice by claims and show cause, and injury and respective claims, whereby Great Britain, Britannica, Crown, the Crown, and all subsidiaries, agency, agents, et will make reparation with punctuality, without question, and whereas, we the people hold, continue, claim, accept and use the Treaty with full jurisdiction for the United States of America being paramount parties in interest, generally recognized by the Treaty, circa 1794, between United States of America and Great Britain, Britannica, Crown, the Crown, and all subsidiaries, agency, agents, et al. And whereas, the following articles of the Treaty are still in effect and define misdeeds, dishonor, and violations committed by the United States Municipal Corporation, agents, employees, actors with England titles of nobility, in violation and trespass of original Article the 13 ratified circa 1819 which others mislabel as the missing 13th Amendment, did unlawfully set aside the original Article the 13 by an act of fraud upon the American people, and a. by the Treaty, November 19, 1794, circa 2012 Article 28. It is agreed that the first 10 articles of this treaty shall be permanent and that the subsequent articles except the 12th shall be limited in their duration to 12 years to be computed from the day on which the ratifications of this treaty shall be exchanged, but subject to this condition that whereas the said 12th article will expire by the limitation therein contained at the end of 2 years from the signing of the preliminary or other articles of peace, and b. by the Treaty, November 19, 1794, circa 2012 Article 1. There shall be a firm inviolable and universal peace, and a true and sincere friendship between His Britannic Majesty, his heirs, and successors, and the United States of America, and between their respective countries, territories, cities, towns and people of every degree, without exception of persons or places, and c. by the Treaty, November 19, 1794, circa 2012 Article 2, they shall be at full liberty to remain there, or to remove with all or any part of their effects, and it shall also be free to them to sell their lands, houses, or effects, or to retain the property thereof, at their discretion. Such of them as shall continue to reside within the said boundary lines shall not be compelled to become citizens of the United States, or to take any oath of allegiance to the government thereof, but they shall be at full liberty so to do, if they think proper, and they shall make and declare their election within 1 year after the evacuation aforesaid. And all persons who shall continue there after the expiration of the said year, without having declared their intention of remaining subjects of His Britannic Majesty, shall be considered as having elected to become citizens of the United States, and d. by the Treaty, November 19, 1794, circa 2012 Article 9. It is agreed, that British subjects who now hold lands in the territories of United States, and American citizens who now hold lands in the dominions of His Majesty, shall continue to hold them according to the nature and tenure of their respective estates and titles therein, and may grant, sell or devise the same to whom they please, in like manner as if they were natives, and that neither they nor their heirs or assigns shall so far as may respect the said lands, be in the legal remedies incident thereto, be regarded as aliens, and e. by the Treaty, November 19, 1794, circa 2012 Article 10. Neither the debts due from individuals from one nation, to individuals of the other, nor shares nor monies, which they may have in the public funds, or in the public or private banks shall ever, in any event of war, or national differences, be sequestered, or confiscated, it being unjust and impolitic that debts and engagements contracted and made by individuals having confidence in each other, and in their respective governments, should ever be destroyed or impaired by national authority, on account of national differences and discontents, and whereas, we the people stand in agreement with the document commonly referred to as the Atlantic Charter, Exhibit 5, circa 1941, stating in part they, United States of America and Great Britain, respect the right of all people to choose the form of government under which they will live, and they wish to see sovereign rights and self-government restored, and whereas, we the people are determined to save succeeding generations from the scourge of war which has brought untold sorrow to mankind, we uphold the Almighty Creator given unalienable human rights, dignity and worth of mankind, we establish justice, and promote the general welfare of all mankind to effect safety and happiness in order to let freedom ring. And towards these ends, we continue to practice tolerance and live together in peace with one another as good neighbors, uniting our strength to maintain international peace and security. We the people desire friendly relations with all the peoples around the world. Accordingly, our respective governments, through representatives assembled on the Republic for the United States of America, who have exhibited their full powers found to be in good and due form, have established an internationally recognized de jure government known as the Republic for the United States of America, a republican form of government, and among the purposes of the Republic for the United States of America are a. To maintain domestic and international peace and security, and to that end, to take effective collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of aggression or other breaches of the peace, and to bring about by peaceful means, and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace, and b. To develop friendly relations and establish principles of honesty and integrity and commerce among nations based on respect for the principle of equal rights and self-determination of all peoples, and c. To cooperate in solving international problems of an economic, social, cultural, or humanitarian nature, promote and encourage respect for the Almighty Creator's given rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, and whereas, we the people favor forgiveness above justice and favor safe harbor over harm for those who repent and sin no more, and whereas, it is the duty of all nations to acknowledge the providence of Almighty God, to obey His will, to be grateful for His benefits, and humbly to implore His protection and favor. George Washington. Now, therefore, we the people herewith give notice that an act to provide governance for District of Columbia, Exhibit 4, dated February 21, 1871, and any related enabling acts are currently before the Republic for the United States of America Congress for repeal, and we the people do hereby claim, accept, adopt and assert jurisdiction and dominion over all. All is defined to mean what it says, all, without prevarication or exclusion, things within our national republic borders including, but not limited to, the following: all fully or partially publicly funded lands, properties, waterways, rivers, lakes, creeks, streams, mountains, hills, valleys, forest, plateaus, caves, deserts, all natural resources, including but not limited to, all assays, minerals, timber, oil, coal, all deposits of any kind, rocks, gravel, sand, water sources above or below ground, flora, fauna, all seeds of any kind, all DNA and DNA records, clones of any kind, non-human and semi-human species, all infrastructure, including, but not limited to, all fully or partially publicly funded post offices, U.S. Postal Service in its entirety, USPS, airports, roads, highways, interstate highways, bridges, seaports, railways, including all related machinery, equipment and supplies, tunnels, all airspace above our borders to the highest height, all underground space below our borders to the lowest depth, all directly or indirectly, fully or partially publicly funded facilities contained within airspace or underground space above or below our borders, all directly or indirectly, fully or partially publicly funded above and below ground facilities including, but not limited to, all military or paramilitary installations, operations, test sites, storage facilities and contents thereof, machinery, equipment, supplies, firearms, all weapons, including but not limited to, smart, nuclear, biological, and bacteriological, which are within, around, near, under, above our national borders, including any and all weapons of mass destruction within, around, without, above, below and in proximity to our national borders, any type of weapon that could pose any threat to our national borders or threaten our military or civilian personnel or our people at any location domestically or internationally, ammunition, supplies, uranium-enriched weapons and all related equipment and supplies, atomic and nuclear weapons and all related equipment and supplies, all experimental weapons and related equipment and supplies, HARP, High-Frequency Active Auroral Research Program, and all related facilities, equipment and supplies, bulk storage for any and all fuels, water or food, all aircraft, ships, boats, watercraft, submarines, undersea craft, land craft, subterranean craft and machinery, submersible craft, space probes, airships, dirigibles, satellites whether conventional, non-conventional, or experimental, terrestrial, extraterrestrial, or intergalactic, or any other type of navigable or non-navigable craft, all funds, trust, accounts of any source that are publicly or partially publicly funded directly or indirectly, held by or on behalf of the United States Municipal Corporation or any subsidiary, corporation, partnership, contractor, or entity thereof, any type assets belonging in ownership or interest to the people of the Republic for the United States of America that is under the direction and control of the United States. This includes all directly or indirectly, fully or partially publicly funded trusts, investment accounts and bank accounts, funds, CAFR funds, trade platforms and private placement platforms for all experimental, secret and black projects, absolute ownership of all currencies, foreign and domestic, held or not held, electronic transfer and data for all banking transactions worldwide and any banking infrastructure, banking access code numbers, PIN numbers and any other public or private access code numbers to any and all bank accounts, funds, investment accounts or any such thing of value, keys, combinations, access codes, passwords to any lockers or storage facilities, natural resources of any and all types, petrodollars of any sort, precious metals of any sort, revenue from all liens and rents, military hardware, software and data for any installation, equipment, all military officers, all mother bonds and proceeds of any kind, enlisted and contract personnel, all assets of governmental departments, divisions, subdivisions, agencies and successors and assigns, including, but not limited to, hardware, appurtenances, furniture, licenses, hereditaments, appliances, fixtures, accoutrements, paraphernalia, software, data, and covert, overt, classified, unclassified, secret, public intellectual property. These funds and assets are to be surrendered to the Republic for the United States of America immediately, and are further ordered to cease and desist the use of any and all forms of credit of the people, all public leases, treaties, contracts, memorandum of understanding, or any agreements of any kind, whether secret, private or public, including or involving, but not limited to, oil, gas, coal, salt, limestone, gypsum, gravel, rock, granite, sand metals, gemstones, uranium, water or natural resources of any kind must be renegotiated, coastal areas, estuaries, marshes, marine habitats and resources of any and all types, any and all assets purchased in full or in part, directly or indirectly, with public monies or credit, and we the people do hereby claim, accept, adopt and assert jurisdiction and dominion over all of the territorial and jurisdictional borders of the Republic for the United States of America, including all areas between the southern borders of Canada to the north and the northern border of Mexico to the south, the Atlantic Ocean to the east, the Pacific Ocean to the west and 200 miles out to sea on all coasts excluding territorial rights of other sovereign nations. Alaska and Hawaii have also requested and have been accepted to be included as equal, free and independent states in Union, republics. This will exclude some territories such as the District of Columbia as defined specifically in the portion of Article 1, Section 8, Clause 17, with respect to the section which states, over such district, not exceeding 10 miles square, as may, by cession of particular states, and acceptance of Congress, becoming a seat of the government of the United States, and some islands upon which foreign countries may have claims and or titles. These claims and or titles may be disputed at some future time. Proper lawful titles will be honored, but the Republic for the United States of America reserves the right to negotiate for a return of these holdings back to the possession of the Republic by honorable means of settlement with the holders. The Republic reserves the right to renegotiate any and all treaties made between the United States Municipal Corporation and any of its officials and foreign nations, entities and powers that have any effect on property rights of the people of this Republic on all public, local and private lands. Treaties affecting private land ownership may be negotiated on behalf of, and only at the request of, the people of the Republic for the United States of America, and we the people duly bound by treaty obligations, do hereby order any and every court, agency, subsidiary, agent, contractor or representative, et al., of the United States Municipal Corporation to deliver lawful remedy and resolution immediately on demand, as proclaimed, stated, and ordered herein, to the people through the Republic for the United States of America elected and or appointed officials in order to facilitate peace between the people on the land within the Republic for the United States territorial and extraterritorial boundaries and the corporate United States territorial and extraterritorial boundaries, i.e. the District of Columbia until the reintegration process is completed, and we the people reserve the right to revise, amend, and extend all claims upon subsequent discovery, and We the people hereby serve notice upon the world that we have re-inhabited the de jure republican form of government of the United States of America, and we treat, and, being injured parties in interest, we proclaim conditions of forgiveness as follows, except regarding those who are deemed to have irreconcilable differences or are deemed to be a potential threat to the republic or the people. Let unmerited forgiveness begin for those who have committed crimes against local peoples. Let them be forgiven. Let them go forth and sin no more. Let all principals and actors of the United States Municipal Corporation and all subsidiaries thereof, et al., who have committed crimes and other injustices against local peoples have safe harbor and sin no more. Let us all live in peace. However, any plan, action, public speech, writing, or communication by said principals or actors against we the people, or our republic, shall be a violation of these terms and shall be remedied by law, and be the people solicit the support of the United States military and others, as ordered, to bring about peaceful reintegration and remedy for we the people and security for our republic. Definitions. We the people, live, sovereign men and women on the land, on free and independent states, in union creating the Republic for the United States of America. Plenipotentiary, a representative of our government vested with full power to transact any business, a representative, an ambassador or envoy to a foreign court or nation, vested with full power to negotiate a treaty or to transact other business. Free, not enslaved, not in a state of vassalage or dependence, subject only to positive laws, made by consent, and to a lawful administration of such laws, not subject to the arbitrary will of a sovereign or lord, ace a free state, nation or people. All equals means what it says, all, without prevarication or exclusion. Local people who domicile within the territorial borders, as established by the Declaration of Sovereign Intent, circa 2010, Exhibit 1, including all naturalized and natural-born men and women. U.S., the United States, the municipal corporation, and all subsidiaries thereof, at a fictional legal entity unlawfully elevated to exist as a sovereign person governing for the people. Reference the Act of February 21, 1871, Exhibit 4. The United States of America, Republican form of governance created by the Constitution, circa 1789, which created the jurisdiction of the land mass defined as America, see definition of America. This government was re-inhabited by we the people on November 15, 2010, now known as the Republic for the United States of America. Involuntary servitude, enslavement of free people against their will and without their consent. American, one who lawfully inhabits, sojourns or domiciles on the land of America, a citizen of the Republic for the United States of America. Constitution, the foundational document created for the United States of America by the Founding Fathers September 17, 1787, ratified circa 1789, Exhibit 2B, and amended circa 1791 to include the Bill of Rights. America, the territorial and jurisdictional borders of the Republic for the United States of America include all areas between the southern border of Canada to the north, the northern border of Mexico to the south, the Atlantic Ocean to the east, the Pacific Ocean to the west, and 200 miles out to sea on all coasts excluding territorial rights of other sovereign nations. Alaska and Hawaii have also requested and been accepted to be included as equal, free and independent republics. See as established by the Declaration of Sovereign Intent, circa 2010, Exhibit 1. Non-injury prosecution, prosecution of a man where there is no victim, i.e. victimless crime. God, the Almighty Creator of all things and the universe. Republic, the united group of free peoples joined together in unity to create a national government. Exhibit 1 Declaration of Sovereign Intent. Adopted November 14, 2010 Republic for the United States of America. We the Congress of the People on the land of the Republic for the United States of America, which name will be used in reference to our Republic in all documents and communication from this day forward, in session in the presence of Almighty God do hereby declare the following to be true and self-evident. We the people on the land of the Republic for the United States of America do hereby declare that, in the year of our Lord 1776, the Founding Fathers created a Declaration of Independence to declare our separation from England. This declaration acknowledges that the people of America have the right to abolish any government they feel is not in the interest of their safety and security. We the people on the land of the Republic for the United States of America do hereby declare that in the year 1791 the Congress of the United States of America, in session, adopted a Constitution for the United States of America and a Bill of Rights. This Constitution affirms that we the people lawfully settled within the territorial boundaries of the Republic for the United States of America have certain equal, inherent, unalienable rights from the Creator Almighty God, which can never be removed, altered or denied by government. We the people on the land of the Republic for the United States of America do hereby declare that, in the years 1868 through 1871, the U.S. Congress established a municipal corporation in Delaware called the United States. This municipal corporation was given a jurisdictional territory of 10 miles square in an area named the District of Columbia. We the people on the land of the Republic for the United States of America do hereby declare that, in the years 1868 to 1871, the U.S. Congress of the Municipal Corporation United States changed our system of law from lawful to a legal system which implemented and enforced laws that were in violation of the spirit and letter of our founding documents. This legal system was imposed upon we the people without notification or lawful consent. The Congress began a march down the road to destruction of the fundamental laws that founded our nation. They implemented non-injury prosecution for the purpose of unlawfully extracting wealth from we the people without our lawful consent. They created deceptive contracting practices that allowed enforcement of contracts and laws without proper full disclosure. Consent cannot be given without lawful full disclosure. We believe this was done with full knowledge, malice, fraud and intent by the United States. We the people on the land of the Republic for the United States of America do hereby declare that, in the year 1913, the legislature created a Federal Reserve System without a lawful majority vote of Congress as is required for a bill to be passed into law. The legislature unlawfully established a banking system that has unlawfully eaten out the substance of we the people by hypothecating and borrowing vast sums of credit that were created from nothing of value. By using this system, Congress has egregiously violated their fiduciary oath and duties to we the people. The result is a hypothecated debt that cannot be repaid to the lender. We believe the corporation United States is bankrupt and insolvent and will certainly fail. We the people of the Republic for the United States of America do hereby declare that, in or about the year 1913, the legislature of the corporation United States created an income tax system to unlawfully tax the earnings of we the people who do not work, earn or reside within the territorial borders of the corporation United States. This unlawful tax has been imposed upon we the people without properly legislated laws and without our lawful consent. Criminal prosecutions have been unlawfully held against millions of we the people under Title 18 United States Code, although this code was never lawfully passed into law by a lawful majority of the legislature. This fraud was perpetrated upon we the people with full knowledge, malice and intent by the U.S. Congress, Internal Revenue, the Internal Revenue Service, and the Federal Reserve. These criminal acts are unconscionable to decent people and will no longer be tolerated. We the people on the land of the Republic for the United States of America do hereby declare that the United States Congress, along with the American Bar Association and the U.S. judicial system, have, with full knowledge, malice, fraud and intent, created a system of prison bonds which have been hypothecated against the lawful property of we the people without their lawful consent. This system of bonding is used to enrich private corporations in violation of the laws of our land and the fiduciary duty of the trustees of the accounts. This system makes it extremely profitable to arrest and convict innocent people for victimless crimes using improperly legislated codes, statutes and ordinances. Thousands of Americans are currently being held in their state and federal prisons under false charges for bogus crimes. Many of these were denied due process rights, challenges to lawful jurisdiction, proper jury selection, habeas corpus and numerous other God-given unalienable rights. These Americans are being held against their will for the exclusive purpose of enriching private corporations. Numerous criminal violations of law have been committed with full knowledge, malice, fraud and intent and will no longer be tolerated by we the people. We the people on the land of the Republic for the United States of America do hereby declare that the United States Congress, in conjunction with the American Medical Association, has, with full knowledge, malice, fraud and intent, authorized the use of legal prescription drugs to poison and destroy the health and lives of the American people. The United States Congress, in conjunction with the American Medical Association and Food and Drug Administration has, with full knowledge, malice, fraud and intent, withheld and suppressed alternative health measures and practices that could have helped improve the quality of life and health of millions of people around the world. We the people on the land of the Republic for the United States of America do hereby declare that the United States has unlawfully used public, local and private lands, properties, infrastructure, facilities, roads, bridges, utilities, public parks and seaports to mortgage and hypothecate against in order to create funds to operate the United States corporate government. This government has, with full knowledge, malice, fraud and intent, abused the assets of the American people without their knowledge or consent to finance abusive spending practices to enrich private corporations. Many of the bills passed by Congress were passed to create fraudulent enterprises that were intentionally over-budgeted in order to pay bribes, graft and kickbacks to many members of Congress. Many of these funds have been deposited in offshore private trust accounts that are controlled by members of Congress. This financial abuse of the public trust has resulted in a debt so large that it could never be paid by the American people. This abuse has placed all of the public and private assets of the people at serious risk, which is a violation of their oaths of office and fiduciary duties to the people. This criminal behavior will no longer be tolerated by we the people. We the people on the land of the Republic for the United States of America do hereby declare that the United States Corporation has unlawfully created bonds for the purpose of effecting title to the American people and that this is tantamount to placing them into slavery, which is contrary to our laws. This was done for the benefit of certain banking interests. This criminal behavior will no longer be tolerated by we the people. Notice of abolishment. In order to form a more perfect union and provide for the peace, safety and tranquility of we the people on the land of the Republic for the United States of America, we do hereby abolish and bar the United States Corporation and all of its sub-corporations and agencies from any actions against members of the Republic within our territorial borders. This only applies to people who have joined the Republic and those who trespass against our laws. It is our desire and intent to do no harm to anyone and to practice forgiveness and restitution upon repentance. We wish only to live in peace and harmony with all, as a free people, as is our right given by the Creator. 1. Therefore, we the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, without imposing or endorsing a national religion, do hereby continue the adoption of the accurate Holy Bible as divine law and the fundamental basis of law form. We ratify and adopt the Declaration of Independence circa 1776, the Constitution for the United States of America circa 1789 and the Bill of Rights circa 1791 as the basis and form for our laws. This law form will be supported by all laws that are passed by Congress and will be upheld and enforced by our judiciary and law enforcement. All interpretations and applications of these laws will be in compliance with the principles of the aforementioned documents that we hold as sacred in our Republic, so help us God. We specifically exclude the portion of Article 1, Section 8, Clause 17, with respect to the section which states over such district, not exceeding 10 miles square, as may, by cession of particular states, and acceptance of Congress, become a scat of the government of the United States. 2. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby claim, accept, adopt and assert jurisdiction and dominion over all. All is defined to mean what it says, all, without prevarication or exclusion, things within our borders including, but not limited to, the following: all fully or partially publicly funded lands, properties, waterways, rivers, lakes, creeks, streams, mountains, hills, valleys, forests, plateaus, caves, deserts, all natural resources, including, but not limited to, all minerals, timber, oil, coal, all deposits of any kind, rocks, gravel, sand, water sources above or below ground, flora, fauna and non-human species, all infrastructure, including, but not limited to, all fully or partially publicly funded airports, roads, highways, interstate highways, bridges, seaports, railways, including all related machinery, equipment and supplies, tunnels, all airspace above our borders to the highest height, all underground space below our borders to the lowest depth, all directly or indirectly, fully or partially publicly funded facilities contained within airspace or underground space above or below our borders, all directly or indirectly, fully or partially publicly funded above and below ground facilities including, but not limited to, all military or paramilitary installations, operations, test sites, facilities, machinery, equipment, supplies, firearms, weapons, ammunition, supplies, uranium-enriched weapons and all related equipment and supplies, atomic and nuclear weapons and all related equipment and supplies, all experimental weapons and related equipment and supplies, HARP and all related facilities, equipment and supplies, bulk storage for any and all fuels, water or food, all aircraft, ships, boats, watercraft, submarines, undersea craft, land craft, subterranean craft and machinery, submersible craft, space probes, airships, dirigibles, satellites whether conventional, non-conventional or experimental, terrestrial, extraterrestrial, or intergalactic, or any other type of navigable or non-navigable craft, all funds, trusts, accounts of any source that are publicly or partially public funded directly or indirectly by any type assets belonging to or under the direction and control of the people of the Republic for the United States of America. This includes all directly or indirectly, fully or partially publicly funded trusts, investment accounts and bank accounts, trade platforms and private placement platforms for all experimental, secret and black projects. These funds are to be surrendered to the Republic for the United States of America immediately upon notification by the Republic for the United States of America to the trustees of the above-mentioned funds and accounts. The territorial and jurisdictional borders of the Republic for the United States of America include all areas between the southern border of Canada to the north, the northern border of Mexico to the south, the Atlantic Ocean to the east, the Pacific Ocean to the west and 200 miles out to sea on all coasts excluding territorial rights of other sovereign nations. Alaska and Hawaii have also requested and been accepted to be included as equal, free and independent republics. This will exclude some territories such as the District of Columbia as defined specifically in the portion of Article 1, Section 8, Clause 17, with respect to the section which states over such district, not exceeding 10 miles square, as may, by cession of particular states, and acceptance of Congress, become a seat of the government of the United States. And some islands upon which foreign countries may have claims and/or titles. These claims and/or titles may be disputed at some future time. Proper lawful titles will be honored, but the Republic for the United States of America reserves the right to negotiate for a return of these holdings back to the possession of the Republic by honorable means of settlement with the holders. The Republic reserves the right to renegotiate any and all treaties with foreign nations, entities and powers that have any effect on property rights of the people of this Republic on all public, local and private lands. Treaties affecting private land ownership may be negotiated on behalf of, and only at the request of, the people of the Republic for the United States of America. 3. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept and adopt the legislative, executive and judicial branches of our government as our lawful government structure. The duties of the legislative branch are to write and pass bills into law and present them to the President to be signed into law. The duty of the executive branch is to develop policies and procedures that will assist in carrying out and enforcing the laws passed by Congress. The duty of the judicial branch is to exercise lawful justice and truth according to the principles of our founding law form. It is not and shall not be the duty or right of the judicial branch to practice, make, or pass law by legislating from the bench. All laws in the Republic must be passed by the legislative branch of the government. The legislative branch is the elected voice of the people and the only branch of government that has limited delegated authority and power to enact law. Any law or decree that is created by any other method is null and void on its face and will not be enforced by any official, officer, agent, or representative of the Republic. The grand juries shall guard the private people against abuse by delegated surrogate power. Enforcing unlawful laws will be a criminal act punishable by law. 4. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept and adopt Article I courts and our one Supreme Court as is provided by the Constitution for the United States of America circa 1789, a nation judiciary court with the ability to operate in common law. These Article III courts and the one Supreme Court will be the only lawful nation courts within our borders. Prosecution of anyone within our borders by any other nation court will be a criminal act punishable by law. This law is not to have any effect on any lawful courts established by the free and independent republics, states, within the territorial borders of the Republic for the United States of America. These free and independent republics have the right to establish courts of their choice at the republic, state, county, parish, borough or municipal level without any interference or involvement from nation courts. District nation courts may operate within these republics only by the invitation of these free and independent republics. 5. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept and adopt the America Rangers as the duly authorized law enforcement agency of the Republic for the United States of America. The America Rangers will have lawful authority to act on the request of the legislative, executive, or judicial branches of the Republic. Their jurisdiction will be within all areas of our territorial boundaries as established by law. They will have the powers of arrest by lawful warrant, Article TV of the Bill of Rights, power to detain by lawful method, power to hold, and power to use force, up to and including deadly force when necessary, to uphold the laws of this Republic. They will not be prosecuted for any lawful action taken while in the performance of their duties. They may be prosecuted for unlawful actions, violating their oath or failure to obey lawful orders by superior officers. They will be authorized to transport and protect prisoners and protect officers of the court, any other officer of the Republic and we the people as needed. The America Rangers will be authorized, by lawful orders given by superior officers, to protect the lives of the officers, agents, representatives, and officials and their families of the Republic by any lawful means. They will be authorized to protect the Republic for the United States of America from all enemies, foreign and domestic, by any lawful means as ordered by their superior officers. A Chief and Deputy Chief America Ranger will be authorized at the nation level as the highest officer in the nation for the America Rangers. Additionally, a Chief and Deputy Chief Ranger at each regional level shall be under the authority of the nation Chief and Deputy Chief America Ranger. Deputies will be placed in each region as needed, as provided by the executive branch of the Republic. The Chief Ranger at the nation level will be responsible for creating all policy and procedure directives that will guide all actions by the Rangers. America Rangers are authorized to act within each of the several republics by consent or invitation by the governor or his representative. The America Rangers will be administered an oath or affirmation and agree to uphold and defend the Constitution of the Republic for the United States of America and all legislated laws by this legislature against all enemies, foreign and domestic. Failure to uphold this oath will be a criminal act and subject to prosecution according to the criminal laws as passed by the legislative branch of the Republic. 6. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept and adopt the current United States military as our military force. This includes but is not limited to all branches of the military such as the Army, Navy, Air Force, Marine Corps, Coast Guard and all reserve officers. Congress will work closely with the current Joint Chiefs of Staff to secure protection of our borders and defense against all enemies foreign and domestic. The President is duly authorized by Congress to be the Commander-in-Chief for the military forces. All orders given to the military leaders by the President will be lawful orders with full authority and consent by Congress. No officer or soldier will be held, charged or punished for a crime when carrying out a lawful order of the President. Congress will appropriate bills as necessary to fund all lawful functions and projects of the military as needed. It is the intent of the Republic to return to a policy in peace with other nations while building a strong national defense. 7. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept and adopt the name of our Republic as the Republic for the United States of America. This name will be used in reference to our Republic in all documents and communication from this day forward so as to differentiate our Republic from the United States Corporation. In all of our written or verbal communication when using the words Republic or America it is understood that this will be a reference to the Republic for the United States of America and has no attachment in any way to the corporate United States government. 8. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept, adopt and establish a post office as our means of distributing the Republic's mail and conducting international commerce among the nations of the world. The location on the land of the Republic for the United States of America seat of government is 6901 Portage Road, Portage, Michigan, near 49,002. The name of our post office will be Post Office of the Republic for the United States of America. We hereby establish a Postmaster General position and sanction the development of this postal service within our borders. We reserve the right to use any existing postal service, whether directly or indirectly publicly funded or partially publicly funded, as our postal service and all of the employees, buildings, facilities, vehicles, equipment and supplies to carry out mail services to local people within the territorial borders of our nation. 9. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept, adopt and establish a nation treasury and nation bank system. This treasury will be called Treasury of the Republic for the United States of America and will be referred to as the Republic Treasury. The Republic Treasury and banks will operate on an established value backed by substance of gold, silver and other precious metals, copper and other semi-precious metals, mineral deposits, oil, coal, uranium, food, land, air, water, natural resources or any other commodity of real value as needed to fund the nation treasury and nation bank system. The people reserve the right to use any currently existing treasury or banks within the territorial borders which are directly or indirectly funded or partially funded with public funds or assets originated from the people within the territorial borders. We hereby reserve the power to design, print and coin money that will be backed by the commodities of our nation as referenced above. We hereby, with this bill, declare it to be unlawful for any Federal Reserve System bank, member bank, associate bank or treasury to operate within our borders or hypothecate upon our assets without the express written consent by a 3/4 majority vote of the Republic for the United States of America. Violation of this law will be a criminal act and will be punishable by our laws. 10. We the Congress of the Republic for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept, adopt and establish a law that makes it a criminal act for any agency, representative, officer, agent, contractor, subcontractor, debt collector or any other person or entity representing the United States corporate government to collect any tax within our territorial borders or from any of our people within our territorial borders without express written consent by a 3/4 majority vote of the members of the Republic for the United States of America. All taxes collected henceforth will be used to fund the Republic for the United States of America for the benefit of the people of our Republic. All agencies of the United States corporate government shall immediately cease or cause to cease assessment and collections of any internal revenue and internal revenue service taxes or any derivative thereof, sales taxes, highway and road taxes, import or export taxes, property taxes, tolls, permit fees, fines for offense of any type, prison bonds, any revenue from prisoners, or any other type of tax, fee, permit, license fee or fine from any person, citizen, resident, alien, corporation, business, firm or any other entity within our territorial borders. Any violation of this law will be a criminal act and will be punishable by the laws of this Republic. 11. We the Congress for the United States of America, assembled in the presence of the Almighty Creator, do hereby accept, adopt and establish a law that declares it a criminal act for any agency, representative, officer, agent, contractor, subcontractor, debt collector, or any other person or entity representing the United States corporate government or any other entity to collect any unlawful debt within our territorial borders or from any of our people within our territorial borders without lawful proof of claim. All debts collected henceforth will require lawful proof of claim at the request of the debtor. In case of dispute, a forensic audit of the bank, creditor or lending institution's records will be required to prove that money of substance was, in fact, loaned to the debtor. This audit will be completed at the expense of the corporation, agency, business, firm, contractor or debt collector who is attempting collection of said debt. This includes any alleged debt by any corporation, agency, business, firm, contractor, debt collector or any other entity within our territorial borders. Any violation of this law will be a criminal act and punishable by the laws of this Republic. This law only applies to people who have joined the Republic and those who trespass against our laws within our territorial borders. No one shall be forced to join the Republic. 12. We do hereby abolish all authority of the Corporation United States or any of its principals, agencies, subcorporations, contractors, subcontractors, employees, officers and representatives of any kind to operate within our borders to carry out any function or operate in any capacity without the express written consent by a 3/4 majority vote of a lawful quorum of this Congress. We do not validate, or consent to any ultra vires acts, superior foreign powers, or omissions of the United States or any of its principals, agencies, subcorporations, contractors, subcontractors, employees, officers or representatives. Number of voting state republics is 36. Number of voting members is 287. Number of yes votes is 287. Number of no votes is 0. The motion was thus unanimously passed. We the Congress of the People on the land of the Republic for the United States of America convened in Assembly on November 14, 2010, hereby place our mark below by absolute autograph by 35 member republics for the United States of America. Exhibit 2 Declaration of Sovereignty for the Republic of the United States of America July 20, 2010. Presented to the Committee of 300, the International Court of Justice United States of America the United Nations, UN, the Universal Postal Union, UPU. Presented by we the people of the Republic of the United States of America. Represented by James Timothy Turner, President Jerry Thomas Peake, Vice President Carl Martin Sedlock, Secretary of State, the unanimous declaration of the sovereign people of the United States of America to restore and re-inhabit the free American republics. We the people inhabiting the North American continent, free men and women convened under God, having been granted by the Creator dominion over all the earth, to restore the blessings of liberty for ourselves and the posterity, do hereby invoke our sacred right to alter or abolish destructive government as memorialized in the unanimous Declaration of the 13 United States of America, circa 1776, by declaring herewith this solemn declaration to the people of the earth and all governments and nations derived therefrom. Whereas we do not now, nor have we ever been possessed of a desire to relinquish any of our unalienable rights of the dubious benefits of limited liability or nay other compelled revocable privileges of a subject class citizenship of the United States, nor to relinquish every aspect of our lives to corporations posing illegitimate governments. Whereas we do not now, nor have we ever entered into a binding contract, agreement or trust relationship with any person, living or fictitious, with a fully informed and willful intent to deprive ourselves or to be deprived by others of any unalienable rights granted to us by the self-existing Creator and guaranteed by the constitutions of the free republics of North America and the United States of America Republic, circa 1787. Whereas we have become aware that each of the free American republics and the constitutional Republic of the United States of America, circa 1787, have been preempted by military power and emasculated by coercive and deceitful methods of economic and political subjugation imposed by corporations posing as legitimate governments. Therefore we the sovereign people of the free American republics do hereby and herewith organize under God for all the world to hear and see upon each state signatories hereto numbering at least 26 souls, as the respective 50, well-regulated guardians of the free republics restore and re-inhabit through this declaration the legitimate constitutional governments of these free republics in peace and harmony, conclude the era of illicit corporate governance by renouncing in the presence of the Creator, forever and without contrived ambiguity, all permissions, delegations of authority and grants of attorney, real or imagined, to corporations posing as legitimate governments, in particular the United States Federal Corporation and all subdivisions thereof assemble upon each state signatories hereto numbering at least 26 souls, de jure grand juries in the people's common law of the land, herein authorized in remedy of the self-evident expositions of truth hereunder to forthwith order and conduct forensic accounting of the various trusts and so-called legacy accounts attributed to the people, facilitate a return to the people of wealth which has been taken by fraudulent artifice on the part of the banking institutions of this or any country, in particular the ill-gotten gains of foreclosure and fraudulent foreign taxation, peacefully eliminate all existing government structures, entities and agencies that have been derived from the de facto corporations posing as legitimate governments, issue orders to the military, police and corporate powers of the land and sea to enforce our divine rights to such lawful government as was already ensured by our constitutions, and restore de facto actors to lawful de jure capacity duly confined by the constitutions of these republics and replace the non-compliant, thus restoring to each and every American their in-law, dry land, divine rights of birth and the fruits of their individual and ancestral labor as quickly, efficiently and discreetly as possible, without causing undue alarm or stress and without malice for anyone. Forgive in the name of the Creator all who repent their political and economic misdeeds. It is hereby so decreed by the sovereign people of these free American republics assembled herein, test made so by our hands, republic by republic, hereinafter following. Warrant of the de jure grand juries of the people of the United States of America assembled under God as guardians of the free republics and sole lawful authority on the land. We the sovereign people inhabiting the free American republics, the well-regulated guardians of the free republics under God, having salvaged the rule of lawful de jure governance and re-inhabited these de jure grand juries by the unanimous declaration of the sovereign people of the United States of America to restore and re-inhabit the free American republics, circa 2010, do hereby invoke our sacred dominion over all the earth and issue this warrant and orders attached hereto to the following men and women presently acting in the incorporated capacities respectively noted thereby, and all successors thereto and nominees thereof, and to all people, governments and nations to whom this warrant and orders necessarily apply. Robert Renfro Riley, a man occupying the office of Governor, Incorporated State of Alabama. Sean R. Parnell, a man occupying the office of Governor, Incorporated State of Alaska. Janice K. Brewer, a woman occupying the office of Governor, Incorporated State of Arizona. Mickey Dale Beebe, a man occupying the office of Governor, Incorporated State of Arkansas. Arnold Alois Schwarzenegger, a man occupying the office of Governor, Incorporated State of California. August William Ritter Jr., a man occupying the office of Governor, Incorporated State of Colorado. Mary Jody Rell, a woman occupying the office of Governor, Incorporated State of Connecticut. Jack A. Markle, a man occupying the office of Governor, Incorporated State of Delaware. Charles Joseph Christ Jr., a man occupying the office of Governor, Incorporated State of Florida. George Irvin Purdue III, a man occupying the office of Governor, Incorporated State of Georgia. Linda Cutter Lingle, a woman occupying the office of Governor, Incorporated State of Hawaii. Clement Leroy Otter, a man occupying the office of Governor, Incorporated State of Idaho. Patrick Joseph Quinn III, a man occupying the office of Governor, Incorporated State of Illinois. Mitchell Elias Daniels Jr., a man occupying the office of Governor, Incorporated State of Indiana. Chester John Culver, a man occupying the office of Governor, Incorporated State of Iowa. Mark V. Parkinson, a man occupying the office of Governor, Incorporated State of Kansas. Stephen Bessier, a man occupying the office of Governor, Incorporated Commonwealth of Kentucky. Piyush Jindal, a man occupying the office of Governor, Incorporated State of Louisiana. John Elias Baldacci, a man occupying the office of Governor, Incorporated State of Maine. Martin Joseph O'Malley, a man occupying the office of Governor, Incorporated State of Maryland. Deval Lordine Patrick, a man occupying the office of Governor, Incorporated Commonwealth of Massachusetts. Jennifer Mulhern Granholm, a woman occupying the office of Governor, Incorporated State of Michigan. Timothy James Palenti, a man occupying the office of Governor, Incorporated State of Minnesota. Haley Reeves Barber, a man occupying the office of Governor, Incorporated State of Mississippi. Jeremiah Wilson Nixon, a man occupying the office of Governor, Incorporated State of Missouri. Brian David Schweitzer, a man occupying the office of Governor, Incorporated State of Montana. David Eugene Heineman, a man occupying the office of Governor, Incorporated State of Nebraska. James Arthur Gibbons, a man occupying the office of Governor, Incorporated State of Nevada. John H. Lynch, a man occupying the office of Governor, Incorporated State of New Hampshire. Private record sample. Confidential. The Save America Crusade, Sarnia John Stevens Curzini, a man occupying the office of Governor, Incorporated State of New Jersey. William Blaine Richardson III, a man occupying the office of Governor, Incorporated State of New Mexico. David Alexander Patterson, a man occupying the office of Governor, Incorporated State of New York. Beverly Eves Purdue, a woman occupying the office of Governor, Incorporated State of North Carolina. John Henry Hoven III, a man occupying the office of Governor, Incorporated State of North Dakota. Ted Strickland, a man occupying the office of Governor, Incorporated State of Ohio. Charles Bradford Henry, a man occupying the office of Governor, Incorporated State of Oklahoma. Theodore R. Kulongoski, a man occupying the office of Governor, Incorporated State of Oregon. Edward Gene Kendall, a man occupying the office of Governor, Incorporated Commonwealth of Pennsylvania. Donald L. Carcieri, a man occupying the office of Governor, Incorporated State of Rhode Island. Marshall Clement Sanford Jr., a man occupying the office of Governor, Incorporated State of South Carolina. Marion Michael Rounds, a man occupying the office of Governor, Incorporated State of South Dakota. Philip Norman Bredesen Jr., a man occupying the office of Governor, Incorporated State of Tennessee. James Richard Perry, a man occupying the office of Governor, Incorporated State of Texas. Gary Richard Herbert, a man occupying the office of Governor, Incorporated State of Utah. James H. Douglas, a man occupying the office of Governor, Incorporated State of Vermont. Robert Francis McDonnell, a man occupying the office of Governor, Incorporated Commonwealth of Virginia. Christine O'Grady Gregoire, a woman occupying the office of Governor, Incorporated State of Washington. Joseph Manchin II, a man occupying the office of Governor, Incorporated State of West Virginia. James Edward Doyle, a man occupying the office of Governor, Incorporated State of Wisconsin. David Dwayne Freudenthal, a man occupying the office of Governor, Incorporated State of Wyoming. Notice. This warrant comprises notice to each and all of the above listed men and women and all agents and nominees thereof and successors thereto, and to all the people, governments and nations of the world, of the re-inhabitation of the legitimate de jure unincorporated republican government institutions pursuant to the constitutions of the free American republics and the United States of America Republic, circa 1787, and the conclusion, termination, voiding and defunding of the de facto office of governor of each of the aforesaid 50 political subdivisions of the United States Federal Corporation. Warrant. The de jure grand juries do hereby unanimously and simultaneously arrest, redeem and recall the bonds, insurance, surety and de facto escrow of the de facto office of governor, state of 4_, real or imagines, in each of the 50 incorporated political subdivision states of the United States Federal Corporation, thereby rendering all such bonds, insurance, surety and de facto escrow instantly null, void and non-negotiable, and the public wanting for indemnification. For purposes herein, the term state also includes the term Commonwealth when referring to the 50 political subdivisions of the United States Federal Corporation and similar de facto institutions. Order. The de facto office of governor of the state of each of the 50 incorporated states of the United States Federal Corporation, and all vestiges thereof, is hereby resorbed into respective de jure office of governor of. For example, New York, of each of the respective 50 free republics of the United States of America, circa 1787, upon the man or woman occupying each such office receiving notice of this warrant. Upon such notice, each such man or woman shall be free to resign within 3 days of receipt of this warrant without recourse for such resignation, to be replaced by the man or woman next in line to occupy such office. Order. At the time of such resorption, or as soon as is practical thereafter, all such men and women accepting the office of governor of a de jure state republic shall take and subscribe the following respective oath in the presence of the Almighty Creator in front of a duly appointed officer of these de jure grand juries, and shall file such oaths with these de jure grand juries before, and as a condition of, occupying the said respective office, such filing to be completed no later than 14 DOS after receipt of this warrant. Failure of these de jure grand juries to timely receive the said oaths shall comprise resignation of the respective party from the respective office. The mandatory oath for the office of governor shall be, I.A.B. do solemnly swear, or affirm, that I will support, preserve, defend and protect the Constitution of the name of state, for example New York not the state of New York, Republic and the Constitution for the United States of America Republic, circa 1787, and that I will perform and fulfill all of the duties of the office of governor of this republic faithfully and impartially to the best of my ability and understanding, as a sacred actionable blood oath contract with the people of the for example New York not the state of New York, Republic, so help me God. Order. All acts of omission and commission undertaken in good faith in furtherance of this warrant and all orders to the governors hereunder or subsequent, are indemnified against recourse by the provisional bond de jure of public indemnification of the guardians of the free republics included in this declaration in its entirety, the said bond providing safe passage for all such acts of good faith. Order. Until further notice, all funds necessary to timely implement this warrant and orders to the governors annexed hereto or subsequent warrants or orders shall be debited against the various assets identified in the respective de facto states' comprehensive annual financial report. Failure to comply with these orders to the governors will result in immediate removal from office by order of the de jure grand juries. First order to the governors of the de jure grand juries of the people of the United States of America. Assembled under God. Cease and desist all foreclosure and collection actions against the sovereign people. The people of your respective states, your family, neighbors and friends who trust in your vigilance, the mothers, fathers, sons, daughters, children and grandparents who harbor expectations that you will first and foremost protect and preserve the posterity, being entitled to relief from a century of economic warfare waged by global money predators. You are hereby ordered by these de jure grand juries to direct the men and women in whether by private session or otherwise, occupying the highest judicial offices and applicable trial judges to forthwith provide full faith and credit to Landmark National Bank v. Kessler, Kansas, Lexus 834, 2009, and citations therein, regarding implementation of strict rules of evidence and verification in all judicial cases involving foreclosure and collection of debt, thus requiring attorneys of records to certify to the court existence of debt in fact under penalty of perjury, barring the testimony of attorneys of record from all hearings in the matter at hand, requiring the exhibition of wedding signed original instruments and contracts as a condition for filing and acting, requiring the appearance in open court of an officer able to testify under penalty of perjury to first and knowledge that such documents are, in fact, lost, requiring exhibition of all ledgers and accounts related to the transaction at issue in particular off-balance sheet journals, requiring exhibition of the initial journal entry which identifies the source of the lender's funds in question, requiring the appearance in open court of a lending officer to certify under penalty of perjury the completeness of all records pertaining to the transaction at hand and first-hand knowledge as to the source of the funds in question, requiring verification of signature on all such documents in question, and requiring timely production of all such evidence and prosecution. You are hereby ordered to direct such men and women to approve within 24 hours all petitions for restraining orders, injunctions or estoppels of any and all administrative or judicial actions which want for any or all of the aforementioned exhibitions and or verifications. Second order to the governors of the de jure grand juries of the people of the United States of America. Assembled under God. Cease and desist all tax-related actions against the sovereign people. The state taxing agencies being unlawful collection arms for the Federal Reserve System and its principal private money predators and war profiteers, being repugnant to the Constitution for the United States of America, circa 1787 and an abomination to mankind, being corrupt beyond repair, assault upon and incarceration of the sovereign people by the government of their creation for failure to accede to thefts of their wealth under the guise of legal process being a sin and repugnant to the Constitution for the United States of America, circa 1787. You are hereby ordered tie these de jure grand juries to direct the man or woman occupying the office of Director, Commissioner or similar officer of the Department of Taxation of your respective incorporated state to cease and desist forthwith all investigations, actions, prosecutions, garnishments, liens, levies, and distress against the sovereign people, all members thereof and all accounts, trusts, artifices and legal fiction derived therefrom, real or imagined, as the result of tax, income tax, property tax, sales tax and / or other tax-related charges and or claims such as failure to file, failure to pay, obstruction and or conspiracy, and any peripheral actions which do not involve a flesh and blood injured party. You are hereby ordered to direct the said men and women to prepare and deliver to these de jure grand juries no later than 30 days after receipt of this order a complete list of all men and women within your state who are currently subject to, or have been subjected during the 10 calendar years previous to the signing of this order, to lien, levy, garnishment, invasion, investigation, distress, harassment, detention, judicial process or similar acts of terrorism, whether past or ongoing, as the result of tax, income tax, property tax, sales tax and or other tax-related charges and or claims such as, but not limited to, failure to file, failure to pay, obstruction and or conspiracy. Third order to the governors of the de jure grand juries of the people of the United States of America. Assembled under God. Cease and desist all judicial and quasi-judicial actions against the sovereign people for crimes which lack an injured party. The people being sovereign with respect to the United States of America Republic, circa 1787, at no time having willingly and knowingly granted standing to a corporate entity masquerading as a legitimate government to pose as an injured party with respect to the people's private affairs, or to impose an artificial personage on the people as a vehicle for presuming the people's submission to a commercial law venue, or to employ the judicial institutions and detention facilities of the free American republics for corporate profit, all such activities comprising crimes against mankind. You are hereby ordered by these de jure grand juries to direct the men and women occupying all judicial offices within your respective state's judicial system to forthwith cease and desist all actions and prosecutions against the sovereign people which want for an injured party and or witnesses willing to testify to first-hand knowledge of the alleged crimes under full liability, or where the injured party is deemed to be a government entity. In particular, all such prosecutions which covertly impose a legal personality and or the admiralty, commercial or administrative law venues upon the sovereign people for the purpose of facilitating such actions. Until further notice, all actions for non-violent crimes involving members of the sovereign people who duly and specifically identify themselves as such shall be referred to these de jure grand juries through procedures to be devised thereby. You are further ordered to direct the said men and women to prepare and deliver to these de jure grand juries within 30 days of receipt of this order a complete list of all men and women who are currently subject to or suffering incarceration, distress, parole or restriction as the result of such prosecution as described hereunder for one of an injured party. Fourth order to the governors of the de jure grand juries of the people of the United States of America. Assembled under God. Provide safe passage through the state republics free from government molestation. The people being sovereign with respect to the United States of America Republic, circa 1787, owing no allegiance or obligation to divulge their private affairs to the government of their creation, possessing the absolute right to peacefully travel, congregate, assemble and worship without government scrutiny or interference and most certainly without sustaining bodily injury, detention, assault, kidnapping and or distress for failure to exhibit state-issued documents which confess to subject class state citizenship. You are hereby ordered by these de jure grand juries to direct the man or woman occupying the office of Secretary of State of your respective state republic to prepare an appropriate verifiable wallet-sized document by which guardians of the free republics will be afforded diplomatic immunity and safe passage through our respective state republic, and by extension, through the United States of America, free from government detention, arrest, hindrance, interference, scrutiny and or molestation, such identification to be ready for production no later than 30 days after receipt of this order and without language diminishing the sovereign people towards of the state or subject class citizenship, with production thereafter to require no greater than 7 days after request. You are further ordered to direct the man or woman occupying the office of Commissioner of Motor Vehicles or similar office in your respective state to prepare an appropriate placard by which motorized conveyances in which a guardian of the free republics has an ownership or possessory interest will be afforded the same full faith and credit as above noted, such placard to be ready for production no later than 30 days after receipt of this order and without language implying government ownership or security interest in such conveyances, with production thereafter to require no greater than 7 days after request. You are further ordered to direct all men and women who occupy the highest law enforcement offices within your respective state to modify all criminal and other information databases, in particular the National Crime Information Center database, to reflect the diplomatic do not detain states of guardians of the free republics who exhibit the aforesaid identification document or equivalent identification or otherwise so identify themselves. 2. Cease random roadblocks and other unlawful detentions. 3. Cease forthwith all acts of violence against those members of the sovereign people who identify themselves as such as fail to exhibit confessions of state subject citizenry and who are the subject of notices of tax lien, bank foreclosures, county tax liens, and other fraudulent commercial artifices issued under color of law. Fifth order to the governors of the de jure grand juries of the people of the United States of America. Assembled under God. Restore the trappings of lawful de jure governance. The people being entitled to notice of the return to lawful de jure governance of the free American republics and the United States of America Republic, circa 1787 as existed prior to December 20, 1860 in a manner that does not disturb the peace and orderly transition, and to demonstrate compliance with these orders to the governors. Symbols of de jure governance. Symbols of the de jure governance shall be restored beginning as follows. You are hereby ordered by these de jure grand juries to direct the necessary judicial and law enforcement officers of your respective state to replace all flags which identify incorporated, military, admiralty, maritime and or commercial law forms with proper colors that identify the de jure law form of the respective free American Republic and the United States of America. C. 1787 in all state institutions, in particular in all state, county and local courtrooms, courthouses, judicial institutions, state buildings and law enforcement facilities no later than 90 days after receipt of this order, thereby proclaiming, in an orderly fashion and without inciting vengeance for decades of crimes past, the preempting of corporate military authority in favor of the divine lawful authority of the sovereign people over their de jure affairs of state. You are further ordered to direct the aforesaid officials to modify, change or replace all signs, flags, emblems, placards, official stationery, business cards, highway signs and websites to remove all references to the office of Governor of the State of in favor of the respective de jure notation Governor of for example New York, no later than 30 days after receipt of this order. You are further ordered to direct the aforesaid officials to modify, change or replace all signs, placards, official stationery, business cards, highway signs and websites to replace all references to the state of with the respective de jure entity notation for example New York, no later than 365 days, 365, after receipt of this warrant. You are further ordered to direct the aforesaid office holders to replace the Great Seal of the State and the Governor's Seal for the purpose of, replacing all references to the office of Governor of the State of with the respective de jure notation Governor of for example New York. 2. Replace all references to the state of with the respective de jure notation, for example New York, and 3. Reflect the coat of arms of the state as existed on December 19, 1860, or the earliest existing coat of arms if your respective state was not in existence on December 19, 1860, all such modifications to be completed no later than 45 days after receipt of this order. Failure to comply with these orders to the governors completely and in good faith or plead necessity for additional time or clarification. See General Order 7. Retaliation or obstruction by corporate officers operating under de facto color of law against any of the signatories hereto or agents hereof acting in furtherance of this declaration is deemed a capital crime. It is so ordered this day of the month, in the year of our Lord 2010 by the affixing hereto of each state's signatories numbering at least 26 souls, duly comprising the de jure grand juries of the free American republics pursuant to the unanimous declaration of the sovereign people of the United States of America to restore and re-inhabit the free American republics, circa 2010. Test made so by our hands, republic by republic hereinafter following. General orders of the de jure grand juries of the people of the United States of America assembled under God as guardians of the free republics and sole lawful authority on the land. 2. Our most beloved fathers, mothers, sons and daughters who have selflessly volunteered to serve as the armed forces of the United States of America, and whom, by your oath to support and defend our Constitution, are entrusted with the sacred duty to protect your families, neighbors, friends, the nation and the posterity, from enemies foreign and domestic currently waging economic warfare against the people and the nation under God, and to all whose diligent action is needed and bound by oath hereto. In particular to Michael Mullen, a man occupying the office of Chairman, Joint Chiefs of Staff, and all successors thereto. James E. Cartwright, a man occupying the office of Vice Chairman, Joint Chiefs of Staff, and all successors thereto. George W. Casey, Jr., a man occupying the office of Chief of Staff, Joint Chiefs of Staff, and all successors thereto. Gary Roughhead, a man occupying the office Chief of Naval Operations, and all successors thereto. Norton A. Schwartz, a man occupying the office of Chief of Staff, United States Air Force, and all successors thereto. James T. Conway, a man occupying the office of Commandant of the Marine Corps, and all successors thereto. Robert Gates, a man doing business as United States Secretary of Defense, and all successors thereto. Jane/John Doe, men and women occupying the offices of the United States Armed Forces and/or Department of Defense. And 2. All others to whom these orders must necessarily apply. Whereas the people of the free American republics have been under military occupation since 1861 and various persistent unlawful states of national emergency having been declared and perpetuated without interruption since 1933 such that freedoms and governmental procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. Para. 1. Introduction. Report 93-549 of the Special Committee on the Termination of the National Emergency, United States Senate, November 19, 1973. Whereas such states of national emergency and hundreds of derivative emergency statutes have been duly confessed by the United States Federal Corporation to delegate to the President extraordinary powers, ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing manners, to rule the country without reference to normal constitutional processes. Para. 2. Forward. Report 93-549 of the Special Committee on the Termination of the National Emergency, United States Senate, November 19, 1973. Whereas the people have been declared enemies of the state through fraudulent means in the private corporate regulation known as the Trading with the Enemy Act, c. 1917, as amended c. 1933, by covertly diminishing their divine sovereign status to the pagan rank of legal fiction U.S. persons thereafter presumed to belligerence with respect to the United States Federal Corporation. Whereas all such events, manipulations, deceptions and libels are wholly repugnant on their face to the constitutions of the free American republics and the Constitution for the United States of America, circa 1787. Whereas the members of the armed forces of the untied states of America are bound by oath to obey proper civilian authority and are guided in that duty by the United States Army and Navy Manual of Military Government and Civil Affairs with respect to recovering domestic territory from enemy occupation, restoring civilian government, retaining property civilian laws, removing high-ranking political officials from office, supervising, controlling and closing civilian courts, protecting money, guarding banking facilities, and releasing political prisoners. Whereas we the people have proclaimed and reclaimed our rightful place as the one and only lawful authority under God and pursuant to the constitutions of the 50 free American republics and United States of America Republic, circa 1787 and have given due notice to the people of the earth and all governments and national derived therefrom. Whereas we the people have re-inhabited the legitimate de jure constitutional governments of the said free republics in peace and harmony. Whereas we the people by the unanimous declaration of sovereign people of the United States of America to restore and re-inhabit the free American republics, circa 2010, have assembled under oath the well-regulated guardians of the free republics in all 50 free American republics. Whereas we the people have re-inhabited under oath he rightful de jure grand juries on the land in all 50 free American republics herein proclaimed as these de jure grand juries or the de jure grand juries as the case may require. Whereas we the people by the warrant and orders to the governors of the de jure grand juries hereunder, have given due notice to the men and women occupying the office of governor of each of the 50 states of the United States Federal Corporation and having recalled them, one and all, to de jure service as governors of their respective free American republics. Therefore, we the people the one and only lawful sovereign authority on the land, do hereby peacefully and honorable, without malice for anyone, issue these general orders to the men and women of the armed forces of the United States of America, all successors thereto and nominees thereof pursuant to their duty by oath to the Constitution for the United States of America, c. 1787, and to all other people, governments and nations to whom these general orders must necessarily apply. General Order 1 of the de jure grand juries of the people of the United States of America assembled under God as: cease and desist all tax-related actions against the sovereign people. The Internal Revenue Service being an unlawful collection arm for the Federal Reserve System and its principal private money predators and war profiteers, being repugnant to the Constitution for the United States of America, circa 1787 and a self-evident abomination to mankind, being corrupt beyond repair, assault upon and incarceration of the sovereign people by the government of their creation for failure to accede to thefts of their wealth under the guise of legal process being a sin and perversion of the Constitution for the United States of America, circa 1787. You are hereby ordered by these de jure grand juries to direct the men and women occupying the de facto judicial offices within the United States Federal Corporation, Eric Holder, a man occupying the office of Attorney General of the United States, Douglas Schulman, a man occupying the office of Commissioner, Penal Revenue Service, and all to whom this lid must necessarily apply, to cease and desist forthwith all investigations, actions, prosecutions, liens, levies, garnishments, collections, and distress against the sovereign people, all members thereof and all accounts, trusts, artifices and legal fictions derived therefrom, real or imagined, as the result of tax, income tax, property tax, sales tax and or other tax-related charges and or claims such as failure to file, failure to pay, obstruction and or conspiracy, and any peripheral actions which do not involve a flesh and blood injured party. You are hereby further ordered to direct the said men and women to prepare and deliver to these de jure grand juries within 30 days of receipt of this general order a complete list of all men and women who are currently subject to, or have been subjected during the 10 calendar years previous to the signing of this general orders, to lien, levy, investigation, distress, harassment, detention, judicial process or similar acts of terrorism, whether past or ongoing, as the result of tax, income tax, property tax, sales tax and or other tax-related charges and or claims such as, but not limited to, failure to file, failure to pay, obstructions and or conspiracy. General Order 2 of the de jure grand juries of the people of the United States of America assembled under God as: cease and desist all foreclosure and collection actions against the sovereign people. The sin of a government holding security interests and secret liens against the people it is supposed to serve, obstructing the people from enjoying the fruits of their own labor, charging the people usury, and forcibly stealing the people's God-given credit and land by fraudulent means and intentional defects of law, being self-evident crimes against mankind. You are hereby ordered by these de jure grand juries to direct the men and women occupying the necessary and relative de facto legislative, executive and judicial offices within the United States Federal Corporation, and Timothy F. Geithner, a man occupying the office of Governor, International Monetary Fund, Michael J. Williams, a man acting as Chief Executive Officer, Fannie Mae, Charles E. Haldeman Jr., a man acting as Chief Executive Officer, Freddie Mac, Karen Gordon Mills, a woman acting as Administrator, U.S. Small Business Administration, Sean L. S. Donovan, a man acting as Secretary, U.S. Department of Housing and Urban Development, Eric Holder, a man occupying the office of Attorney General of the United States, and all to whom this order must necessarily apply, to cease and desist forthwith all foreclosure and collection actions against the sovereign people and members thereof and or contrived legal personalities hypothecated therefrom using all necessary means and processes, and further to timely notify all such members of the people as to the cessation of such actions. You are hereby further ordered to direct the said men and women to prepare and deliver to these de jure grand juries within 30 days of receipt of this general order a complete list of all men and women who are currently subject to, or have been subjected within the 10 calendar years previous to the signing of this general order to such foreclosure and/or collection actions as would be subject to the protections afforded by the previous paragraph but for the timing of such foreclosure and collection actions. Introduction. The following outline is a generalization for the purpose of illustrating and conveying the Republic of the United States of America's re-inhabitation, intentions, policies and commitments domestically and internationally. With numerous variables for discussion in each and every sector conveyed or not conveyed, it is not the purpose of this declaration to address every issue in full detail, but rather to present a brief overview of selected topics in order to gain domestic and international support from the receiving parties. Certain names and signatures have been omitted for the privacy and security of all government officials involved and will be made available with discretion upon request. 1. Mission Statement. Our mission is to lawfully re-inhabit the de jure government of the Republic of the United States of America according to the principles set forth by the Constitution circa 1791 for the United States of America. We are committed to restoring the Bill of Rights to the people, protecting property rights, conducting honorable commerce and trade, contracting and being contracted with, paying lawful debts, discouraging slavery and poverty, encouraging the development of technologies, feeding the hungry, clothing the naked, housing the homeless, healing the sick and fulfilling other humanitarian needs around the world. It is our mission to coexist with the corporate administrative government that currently occupies the District of Columbia. It is not our intent to hinder, harass or interfere with the operations of the United States Corporation. Rather it is our intent to establish a lawful government, convene Congress and establish executive, legislative and judicial branches of this government. This effort will protect the basic God-given rights to the people of the free republics within our borders. We will abide by the principles contained in the law of nations, all treaties and agreements to which we are lawfully bound. We request international recognition as a lawful sovereign government to which we the people have the unalienable right. It is our belief that the United States Corporation is bankrupt, insolvent and will certainly collapse economically and irreparably. In preparation and anticipation of this imminent collapse of the United States Corporation, our plan is to implement lawful government, stabilize the economy and prevent anarchy, civil war and martial law in America, and around the world. 2. Re-inhabitation. A. History. In 1776 after the America's victory in the War for Independence, a new government was born. In 1791, the founding fathers of our nation created what is called the Constitution for the United States of America. This document was one of the founding documents that included the Declaration of Independence and the Bill of Rights. This document was ratified in 1791 and governed our nation until 1868 when the United States Corporation was created. At that time, the 41 Congress of the U.S. voted to create a district called the District of Columbia. This district was an autonomous area that was created as a seat of the corporate government that was independent of all of the 50 republics. Its jurisdiction was 100 square miles and this continued until 1974 when it was reduced to 68 square miles, after the state of Virginia reclaimed a portion of its land from the district. Congress at that time drafted a new constitution known as the Constitution of the United States. This constitution was brought forward without the consent of the American people, and since that time, the American people has been governed by a new constitution that was not ratified by the people and did not have their consent. Congress did this quietly behind the scenes to deceive the American people and force the people into slavery. Later, they added territories to this jurisdiction such as Alaska, Hawaii, the Philippines, Guam, Puerto Rico, the Virgin Islands, etc. Every law that was ever passed by the Congress of the Corporation only applied to United States corporate citizens. It never had any lawful authority on a citizen in any of the contiguous 48 states except by their consent or by contract. This change in our government brought about a new legal system that operates on deception and deprivation of the rights of we the people. To make it legal, the system uses a process of tacit agreement, implied consent, and fraudulent contracts to bring we the people under the jurisdiction of this municipal corporation. The judiciary used this system to bring Americans under the jurisdiction of color of law. This is the only law they can use since they did not get the consent of the people to change the Constitution which was founded on God's law. We the people did not say no and Congress used this as our acquiescence and agreement to make and enforce color of law statutes, ordinances, and regulations that were many times legal for United States citizens but not lawful for Americans. This allowed Congress and the judiciary to enslave a nation of free people and imprison many in a system that used hypothecation of prison bonds to make huge sums of money off of the hardship of millions of formerly free people. This system operated from 1878 until March 30, 2010, when we the people said it is finished. B. Lawful right to re-inhabit. The lawful right to re-inhabit is inherent in the Declaration of Independence circa 1776. The Declaration, one of our founding documents, declares our right to change, alter or abolish any system of government that we believe is contrary to the safety and security of the American people. We the people re-inhabited our lawful de jure government on March 30, 2010, by serving notice on the de facto corporation, known as the United States. A lawful grand jury in each of the 50 republics created a new Declaration of Independence that was lawfully served on the corporate United States, informing them that the original de jure government was restored. We the people of the United Republics are the only lawful government within the borders of the United States of America. We have claimed our right to exist as a free and independent people on our land, thus exercising our God-given unalienable rights as defined in our Constitution and the Bill of Rights. 3. De jure government. A. Structure. I. Executive Committee. For better representation of we the people, an executive committee has been formed by the guardian elders of the Restore America plan to facilitate the restructuring of the lawful de jure government of the Republic of the United States of America. This committee has been lawfully sanctioned by a 2/3 majority vote of we the people, and is currently functioning in its lawful capacity to restore the executive, legislative and judicial branches. 1. The Executive Committee's first responsibility is to facilitate and convening Congress, and to reinstate the elections that will establish the government back into the hands of the people, for the people and by the people. 2. The second function is to create policy and procedure directives for each agency of the government that will support constitutional laws passed by Congress. 3. The Executive Committee also holds the responsibility for obtaining the funding in order to appropriately establish a lawful domestic treasury for the Republic of the United States of America. 2. Executive Branch. 1. Function. The executive branch of government is guided by the President of the de jure Republic of the United States of America. The Secretary of State acts as the head of state for international diplomatic relations. The cabinet positions create and implement policies to guide each agency or department by lawful governance for the benefit of we the people and the benefit for all of humanity. 2. Offices. The following offices have been filled by a 2/3 majority vote conducted by we the people on the land of the 50 de jure republics, and are currently operational. Congressional delegates are being selected at this time, and Congress is currently being convened in order to fulfill the full establishment of lawful government offices of the Republic of the United States of America. The President, Vice President and Executive Cabinet positions have been lawfully occupied by the consent of we the people through a 2/3 majority vote conducted, authorized and finalized on July 20, 2010 by the de jure grand juries. Executive branch positions include: A. President. B. Vice President. C. Secretary of State. D. Secretary of Defense. E. Secretary of Treasury. F. Secretary of Transportation. G. Attorney General. H. Secretary of Agriculture. I. Secretary of Homeland Security. J. Secretary of Energy. K. Secretary of Education. L. Secretary of the Interior. M. Secretary of Commerce. N. Secretary of Health and Human Services. O. Secretary of Housing and Urban Development. P. Secretary of Labor. Q. Secretary of Veterans Affairs. R. Director of Central Intelligence Agency. S. Director of the Federal Bureau of Investigation. 3. Legislative Branch. 1. Function. The function of the legislative branch is to convene Congress and create laws that guide the policies of the executive and judicial branches. 2. Offices. Senators and representatives are being appointed by we the people of each of the 50 republics by a 2/3 majority vote. 4. Judicial Branch. 1. Function. The function of the judicial branch is to establish lawful courts, and to examine, administer and enforce constitutional law through the de jure court process. 2. Offices. Supreme Court justices will be appointed by the President and approved by a 2/3 majority vote by Congress and will hold a term as set forth by Congress. B. Republic of the United States of America Headquarters Domicile. The headquarters for the Republic of the United States of America is domiciled at 6901 Portage Road in Portage, Michigan 49002. C. Operational Authority. The following documents comprise our authority to operate as a free nation. I. Declaration of Independence, refer to Exhibit A. 2. Constitution for the United States of America, refer to Exhibit B. 3. The Bill of Rights, refer to Exhibit C. 4. Treaties. 4. Domestic policies. A. Trade and commerce. I. Agriculture and farming. We intend to support agriculture and farming by 1. Providing affordable funding as well as grant assistance to farmers. 2. Providing additional support for small business farming production. 3. Promoting organic methods. 4. Minimizing the use of genetically modified seeds. 5. Promoting the production and use of heirloom seeds. 6. Creating policies that will eliminate overregulation. 7. Supporting small farming operations. 8. Stabilizing prices. 9. Restoring the national strategic grain reserves. 10. Minimizing the use of harmful pesticides and chemicals. 2. Large corporation and big businesses. It is in the best interest of we the people to support large corporations and big businesses. Commerce is what drives our primary principle of capitalism. However, policies and regulations must be careful not to favor any sector or type of business. Rather, integrity and fairness should be the basis of any policies and regulations throughout the various industries. B. Banking, monetary and financial sectors. I. Promoting the development and standardization of a collateral-based monetary system. 1. It will be the policy for the Republic of the United States of America to assist in the comprehensive development, globalization and enforcement of a standardized collateral-based monetary system. 2. Many facets of the Basel Accord initiative set forth by the Financial Stability Board, FSB, are comprised to create stabilization in the currently failing banking communities around the world. It will be the emphasis of we the people to ensure that the policies implemented within our independent banking system will not be based on usury, extortion, profiteering from war desolation or the overhypothecation of the fiat monetary supply. 3. It is our initiative to develop a parallel, internationally recognized and accepted private banking system outside of and independent to the currently overhypothecated monetary banking system of the world today. We will offer incentives for participating nations to join in international commerce with the Republic of the United States of America. 4. This initiative will be driven by the fact that our currency will solely be supported by a strong collateral base of precious minerals and metals, securing our domestic and foreign banking/monetary policies. The overall effect will be the stabilization of the world economies and the protection from overhypothecation of fiat currencies. This will prevent hyperinflation and large fluctuations of the economies around the world. 2. Risk management. We will establish consistent oversight by qualified third-party banking actuaries disciplined in risk management and loss prevention. Their duties will consist of 1. Monitoring domestic budget and expenditure for integrity and accountability. 2. Development of wealth management strategies to increase GDP through suggested fiscal policies as presented for congressional approval. 3. Microfinance. It is the agenda of the United States of America to focus on assisting and edifying the small business owner through the provision of microfinance with low interest requirements accounting primarily for administration processes, facilities and operational personnel facilitating the financing. With a focus on bottom-up economics, we can more rapidly stabilize the domestic economy through each of the individual commerce sectors. 4. Government grant assistance. A comprehensive grant assistance sector will be developed to provide not only financial assistance to the small business and big business sectors, but will also account for provisionally required education for all grant recipients in the subject of stewardship and tailored technological advancements established for the increased productivity of their individual industrial/business sectors. B. Humanitarian sector. It will be our policy to develop and enforce financial acceleration and wealth management programs in order for the enhancement of stability, productivity and longevity of key humanity and environmental funding issues. VI. Military and militia appreciation programs. The sacrifice put forth by the men and women serving in the capacity to protect our borders and foreign relations render a well-deserved opportunity for appropriately accelerated wealth management policies. It is in the banking agenda of we the people to extend this appreciation through specially developed retirement plans appropriately rewarding the sacrifice of our men and women serving in either the military or the militia of our nation. C. Technology. I. Alternative energy. To provide the development, production and promotion of alternative energy sources, to include 1. Free energy. 2. Hydrogen technology. 3. Geothermal. 4. Wind, solar and water technologies. 5. Mechanical, magnetic and electrical resonance. 2. Traditional energy. It is recognized that oil commodity and nuclear energy production is important both domestically and globally. Though we the people have the interest in exploring new horizons of alternative energy, we do not intend to abolish or inhibit the global production and distribution of either industry sector, but rather, we aim to support fair open market business practices and allow for new sectors of energy provision. IV. Healing technologies. 1. Promoting suppressed technologies for treatment of disease. 2. Ozone and oxygen technology. 3. Frequency technology. 4. Pharmaceutical industry. 1. We the people recognize the importance of the pharmaceutical industry and the impact that it has on the healthcare community. It is our goal to support ethical policies, regulations and standards in concordance with fair business practices to allow for equal opportunity competition between conglomerates, corporations and small business factions. 2. It is also our goal to provide government funding assistance and incentive programs to pharmaceutical conglomerates, corporations and small businesses that manufacture preventative medicines. B. Space Program. 1. Fund various NASA projects. 2. Work with international entities to support various space projects. 3. Develop and implement new satellite technologies for communications. 4. Develop advanced and energy-efficient space transport vehicles. VI. Other suppressed technologies. Promote, develop and release advanced technologies for the benefit of mankind. D. Healthcare. I. Access to and delivery of free and low-cost essential and effective healthcare. 2. Redirect healthcare policies to preventative and homeopathic, rather than allopathic measures. 3. Release and implementation of cures to cancer, AIDS and other diseases. 4. Make healthcare readily available to developing nations. E. National security. I. Homeland defense. 1. Ensure emergency preparedness and response, Federal Emergency Management Agency FEMA. 2. Provide critical infrastructure protection. 3. Protect the jurisdiction of the free republics. 4. Develop non-combatant biodefense and biosafety measures. 5. Improve anti-terrorist surveillance and response. 6. Enhance border security and streamline immigration administration. A. Stabilize illegal immigration by increasing economic opportunity in bordering nations. B. Improve procedures that make legal immigration possible. 2. Military. 1. Restructuring of policy. In the past, it has been the policy of the military-industrial complex of the United States Corporation to invade, attack and control other nations for profit. It is the policy of we the people of the Republic of the United States of America de jure government to recall the majority of military forces from around the world which are being used improperly to create large fortunes for private corporations. These military forces will be used for the protection of our borders. It is not our intention to be the policing agency for the nations while taking control and profiting from their natural resources. 2. Agenda. It is our intent to be readily available to assist other nations in their defense and in their humanitarian efforts when called upon to do so. 3. Benefits. A. Reducing the cost of military operations. B. Improving relations with other nations. C. Improving the overall safety, security and stabilization of the global community. D. Control and non-proliferation of nuclear, radiological, biological, chemical and smart weapons. E. Improving the financial assistance, medical and psychological care of the veterans and their families. F. Promoting the honor and respect for all our military heroes and their families. G. Improving veterans services. H. Assisting other nations to be economically and politically independent. 3. Militia. The purpose of the independent state militias is to assist our military in protecting our borders, quelling disturbances, providing aid during emergencies, supporting humanitarian efforts, and protecting the American Republic when needed. These militias are under the direction of each state governor. 1. Reintroduce lawful state militias under state rule. 2. Provide professional training, equipment and supplies. 3. Provide salaries and benefits for militia members. 4. Encourage participation of former military to help stabilize the structure of the militia. 5. Create policies that encourage militias to be complementary to active duty military. 4. Intelligence agencies. Improve relations to promote respect between we the people and the following agencies. 1. Federal Bureau of Investigation, FBI. 2. Central Intelligence Agency, CIA. 3. National Security Agency, NSA. 4. Homeland Security. 5. Law enforcement agencies. F. Environmental policies. I. Global warming. Study factual scientific data to determine our true and current position on global warming. 2. Protection of air, land and water. Create policies to protect our air, land and water from contamination. 3. Recycling and waste management. Provide alternate means of waste disposal that are environmentally friendly and promote recycling programs for disaster management. Create policies that provide timely and efficient disaster mitigation, response and management in America and around the world. V. Foreign policies. A. Trade and commerce. I. Agriculture and farming. We intend to support agriculture and farming in foreign nations by 1. Providing healthy grain supplies to emerging nations. 2. Providing agricultural education, funding and assistance to emerging nations around the world. 2. Large corporations and big businesses. 1. It is in the best interest of we the people to support large corporations and big businesses. Commerce is what drives our primary principle of capitalism. However, policies and regulations must be careful not to favor any sector or type of business. Rather, integrity and fairness should be the basis of any policies and regulations throughout the various industries. B. Banking. I. Promote the development and standardization of a collateral-based monetary system acceptable for international commerce standards. 1. It will be the policy for the Republic of the United States of America to participate and assist in the comprehensive development and globalization of a standardized collateral-based monetary system. The improvement of liquidity and increase of banking reserve standards should be a primary focus for the stabilization of the global economy. 2. Though many facets of the Basel Accord initiative are comprised to create stabilization in the currently failing banking communities around the world, it will be our emphasis to ensure that the policies implemented within our parallel and independent banking system are not based on usury, extortion, profiteering from war, desolation or over-hypothecation of the monetary supply. 3. It is our intent to develop a parallel, internationally recognized and accepted private banking system outside of the currently over-hypothecated fiat banking system of the world today. We will offer mutually beneficial incentives for participating nations to join in international commerce and currency exchange with the Republic of the United States of America. 4. This initiative will be strongly driven by the fact that our currency will be completely supported by a strong collateral base of precious minerals and metals, thus securing our domestic and foreign banking and monetary policies. The overall effect will be the stabilization of the world economies and the protection from over-hypothecation of fiat currencies. This will prevent hyperinflation and large fluctuations of the currencies and economies around the world. 5. It is the policy of we the people of the United States of America Republic to hold high standards of honor, integrity and duty while conducting international commerce, while at the same time committing to support any nation willing to participate within our banking program. We pledge by our sacred honor to protect and support both financially and logistically our fellow brethren in countries around the world in order to improve their quality of life and standard of living. 2. Risk management. We will establish consistent and redundant oversight by qualified first and third-party banking actuaries disciplined in risk management and fiscal policy as well as loss prevention. This assistance will be provided to participating nations without interfering with the host nation's government policies or sovereignty. Their duties will consist of 1. Monitoring grant assistance funding and expenditure for integrity and accountability, limiting expenses only to infrastructural development and other humanitarian purposes. Any covert operations within participating nations to siphon off non-governmental organization, NGO, funding or government grant assistance toward military application, personal gain or profiteering, will be eliminated from any financial assistance offered from the Republic of the United States of America. 2. To provide training and assistance in the development and offered support of wealth management strategies, technological advancements, business stewardship in order to increase foreign participating nation gross domestic product, GDP, through suggested fiscal policies as presented for host government approval and sanctions. It is our ultimate goal to improve the standard of living within many emerging nations without interfering with their government policies or sovereignty. 3. Microfinance for foreign nations. It is in the agenda of the United States of America to focus on assisting, edifying and streamlining processes for small business owners by the provision of microfinance with low interest requirements. Fees will primarily be set accordingly, in order to compensate for the necessary administration processes, facilities and operational personnel assisting with the financing. With a focus on bottom-up economics, we can more rapidly stabilize the foreign economy through each of the individual commerce sectors. For example, standardization and streamlining would provide greater control of the large and rapid daily fluctuation of pricing within the global commodities market. From educating, communicating and unifying all stages from production, to intermediary participants, to global distribution, we can moderate and maintain quality standards for all businesses involved in the process from the start to the finished product. 4. Government grant assistance. A comprehensive grant assistance sector will be developed to provide not only financial assistance to the small business and big business international sectors, but will also account for provisionally required education for all grant recipients regarding the subjects of stewardship and tailored technological advancements which are established to increase their productivity within their individual industrial and business sectors. B. Humanitarian sector. It will be our policy to develop and globally assist financial acceleration and wealth management programs in order for the enhancement of stability, productivity and longevity of key humanity and environmental funding issues. C. Technology. I. Alternative energy. To provide the development, production and promotion of alternative energy sources throughout participating nations, to include 1. Free energy. 2. Hydrogen technology. 3. Geothermal. 4. Wind, solar and water technologies. 5. Mechanical, magnetic and electrical resonance. 2. Traditional energy. It is recognized that oil commodity and nuclear energy production is important both domestically and globally. Though we the people have the interest in exploring new horizons of alternative energy, we are not looking to abolish or inhibit the global production and distribution of either industry sector, but rather, we aim to support fair open market business practices and allow for new sectors of energy provision. 3. Healing technologies. Make suppressed technologies for treatment of diseases available for participating nations. 4. Pharmaceutical industry. 1. We the people recognize the importance of the global pharmaceutical industries and the impact that it has on the humanity. It is our goal to support nations that practice ethical policies, regulations and standards in concordance with fair business practices that allow equal opportunity competition between conglomerates, corporations and small business factions. 2. It is also our goal to provide grants and incentive programs to global pharmaceutical conglomerates, corporations and small businesses that manufacture preventative medicines and advancing healthcare technologies. B. Space program. We the people pledge to work in cooperation with international entities to support various space projects on the global level. Vi. Other suppressed technologies. Promote, develop and release advanced technologies for the benefit of mankind. D. Healthcare. It is our immediate initiative to bring technologically advanced healthcare and ongoing training programs to be provided in nation, and through video conference, made readily available to participating developing nations. E. Military policy restructuring. I. It has in the past been the policy of the military-industrial complex of the United States Corporation to invade, attack and control other nations for profit. It is the policy of we the people of the Republic of the United States of America de jure government to recall the majority of military forces from around the world which are being used improperly to create large fortunes for private corporations. It is not our intention to be the policing agency for the nations while taking control and profiting from their natural resources. It is our intent to assist in defense and humanitarian efforts. F. Environmental policies. I. Global warming. Study factual scientific data to determine our true and current position on global warming and share findings to other nations. 2. Protection of air, land and water. Share air, land and water protection policies to other participating nations. 3. Recycling and waste management. Share alternate means of waste disposal that are environmentally friendly and promote recycling programs. 4. Disaster management. Create policies that provide timely and efficient disaster mitigation, response and management throughout the world. Vi. Request for international support. A. Representation in the United Nations. We respectfully request equal representation and a seat in the UN. B. Recognition by The Hague and the Universal Postal Union. I. We request recognition by The Hague and World Courts, which is our right as a nation. 2. We request recognition and equal treatment as a nation by the Universal Postal Union, UPU, in international commerce. C. Request for the protection by the United Nations and NATO. We request the opportunity for talks to provide protection. We request assistance by UN and NATO if called upon to protect our nation against enemies foreign and domestic. 7. Domestic and international travel. We request for domestic and international recognition of all our identification, travel and commercial documents as a lawful nation under treaty. We also request that diplomatic status be afforded to all diplomatic representatives of our nation. A. Identification. I. National card. The following is an example of our American National Identification Card. This card will be issued to we the people who are domiciled on the soil of any of the free republics of the United States of America. 2. Diplomatic card. The following is an example of our diplomatic identification card. This card will be issued to all diplomats representing the government of the United States of America. 3. Government card. The following is an example of our government identification card. This card will be issued to all government officials representing the Republic of the United States of America. B. Passport. The following is an example of our passport. This passport will be issued to we the people who are domiciled on the soil of any of the free republics of the United States of America. Exhibit 2A. The U.S. National Archives and Records Administration. The Declaration of Independence. www.archives.gov. A transcription. In Congress, July 4, 1776. The unanimous declaration of the 13 United States of America. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth, the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form, as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown, that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object evinces a design to reduce them under absolute despotism, It is their right, it is their duty, to throw off such government, and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained, and when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly, for opposing with manly firmness his invasions on the rights of the people. He has refused for a long time, after such dissolutions, to cause others to be elected, whereby the legislative powers, incapable of annihilation, have returned to the people at large for their exercise, the state remaining in the meantime exposed to all the dangers of invasion from without, and convulsions within. He has endeavored to prevent the population of these states, for that purpose obstructing the laws for naturalization of foreigners, refusing to pass others to encourage their migrations hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice, by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone, for the tenure of their offices, and the amount and payment of their salaries. He has erected a multitude of new offices, and sent hither swarms of officers to harass our people, and eat out their substance. He has kept among us, in times of peace, standing armies without the consent of our legislatures. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution, and unacknowledged by our laws, giving his assent to their acts of pretended legislation. For quartering large bodies of armed troops among us. For protecting them, by a mock trial, from punishment for any murders which they should commit on the inhabitants of these states. For cutting off our trade with all parts of the world. For imposing taxes on us without our consent. For depriving us in many cases, of the benefits of trial by jury. For transporting us beyond seas to be tried for pretended offenses. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. For taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. For suspending our own legislatures, and declaring themselves invested with power to legislate for us in all cases whatsoever. He has abdicated government here, by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coasts, burnt our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation and tyranny, already begun with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages, and totally unworthy the head of a civilized nation. He has constrained our fellow citizens taken captive on the high seas to bear arms against their country, to become the executioners of their friends and brethren, or to fall themselves by their hands. He has excited domestic insurrections amongst us, and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare, is an undistinguished destruction of all ages, sexes and conditions. In every stage of these oppressions we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant, is unfit to be the ruler of a free people. Nor have we been wanting in attentions to our British brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and of consanguinity. We must, therefore, acquiesce in the necessity, which denounces our separation, and hold them, as we hold the rest of mankind, enemies in war, in peace friends. We, therefore, the representatives of the United States of America, in General Congress, assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name, and by authority of the good people of these colonies, solemnly publish and declare, that these united colonies are, and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain, is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes and our sacred honor. The 56 signatures on the declaration appear in the positions indicated. Georgia: Button Gwinnett, Lyman Hall, George Walton. North Carolina: William Hooper, Joseph Hughes, John Penn. South Carolina: Edward Rutledge, Thomas Hayward Jr., Thomas Lynch Jr., Arthur Middleton. Massachusetts: John Hancock. Maryland: Samuel Chase, William Paca, Thomas Stone, Charles Carroll of Carrollton. Virginia: George Wythe, Richard Henry Lee, Thomas Jefferson, Benjamin Harrison, Thomas Nelson Jr., Francis Lightfoot, Lee Carter Braxton. Pennsylvania: Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Clymer, James Smith, George Taylor, James Wilson, George Ross. Delaware: Caesar Rodney, George Reed, Thomas McKean. New York: William Floyd, Philip Livingston, Francis Lewis, Lewis Morris. New Jersey: Richard Stockton, John Witherspoon, Francis Hopkinson, John Hart, Abraham Clark. New Hampshire: Josiah Bartlett, William Whipple. Massachusetts: Samuel Adams, John Adams, Robert Treat, Payne Elbridge, Jerry. Rhode Island: Stephen Hopkins, William Ellery. Connecticut: Roger Sherman, Samuel Huntington, William Williams, Oliver Walcott. New Hampshire: Matthew Thornton. Exhibit 2B, Constitution for the United States of America. Documents from the Continental Congress and the Constitutional Convention, 1774 to 1789. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article I. Sect. 1. All legislative powers, herein granted, shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Sect. 2. The House of Representatives shall be composed of members chosen every second year by all the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years, and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be appointed among the several states which may be included within this Union, according to the respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Sect. 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the fourth year, and of the third class at the expiration of the sixth year, so that 1/3 may be chosen every second year, and if vacancies happen, by resignation or otherwise, during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote, unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore, in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall by on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment, in cases of impeachment, shall not extend further than to removal from office, and disqualification to hold and enjoy any office of honor, trust or profit, under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment and punishment, according to law. Sect. 4. The times, places and manner, of holding elections for senators and representatives, shall be prescribed in each state by the legislature thereof, but the Congress may at any time, by law, make or alter such regulations, except as to the place of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. Sect. 5. Each house shall be the judge of the elections, returns and qualification, of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members, in such manner, and under such penalties, as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and, with the concurrence of 2/3, expel a member. Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. Sect. 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law, and paid out of the Treasury of the United States. They shall in all cases, except treason, felony and breach of peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, where the emoluments whereof shall have been increased, during such time, and no person holding any officer under the United States shall be a member of either house, during his continuance in office. Sect. 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments, as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections, to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But in all such cases the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution or vote, to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. Sect. 8. The Congress shall have power to lay and collect taxes, duties, imposts and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts and excises, shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations, and among the several states, and with the Indian tribes. To establish an uniform rule of naturalization, and uniform laws on the subject of bankruptcies, throughout the United States. To coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation, in all cases whatsoever, over such district, not exceeding 10 miles square, as may, by cession of particular states, and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Sect. 9. The migration or importation of such persons as any of the states now existing shall think proper to admit, shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder, or ex post facto law, shall be passed. No capitation or other direct tax shall be laid, unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the Treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office or title, or any kind whatever from any king, prince, or foreign state. Sect. 10. No state shall enter into any treaty, alliance or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the new produce of all duties and imposts, laid by any state, on imports or exports, shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. Article EL. Sec. 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and, together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative, or person holding an office of trust or profit under the United States, shall be appointed an elector. The electors shall meet in their respective states, and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority, and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President, and if no person have a majority, then from the 5 highest on the list the said House shall in like manner choose a President. But in choosing the President the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors, shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing the electors, and the day on which they shall give their votes, which day shall be the same throughout the United States. No person, except a natural-born citizen, or a citizen of the United States at the time of the adoption of this Constitution, shall be eligible to the office of President, neither shall any person be eligible to that office, who shall not have attained to the age of 35 years, and been 14 years a resident within the United States. In case of the removal of the President from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly, until the disability be removed, or a President shall be elected. The President shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States, or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear, or affirm, that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect and defend, the Constitution of the United States. Sect. 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he may require the opinion, in writing, of the principal officer in each of the executive departments, upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other offices of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate, by granting commissions, which shall expire at the end of their next session. Sect. 3. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Sect. 4. The President, Vice President, and all civil officers of the United States, shall be removed from office, on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 3. Sect. 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office. Sect. 2. The judicial power shall extend to all cases in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state, or the citizens thereof, and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Sect. 3. Treason, against the United States, shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason, unless on the testimony of 2 witnesses to the same overt act, or on concession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood, or forfeiture, except during the life of the person attainted. Article 4. Sect. 1. Full faith and credit shall be given in each state to the public acts, records and judicial proceedings, of every other state. And the Congress may by general laws prescribe the manner in which such acts, records and proceedings, shall be proved, and the effect thereof. Sect. 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person, charged in any state with treason, felony, or other crime, who shall flee from justice, and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up, to be removed to the state having jurisdiction of the crime. No person, held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up, on claim of the party to whom such service or labor may be due. Sect. 3. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations, respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed, as to prejudice any claims of the United States, or of any particular state. Sect. 4. The United States shall guarantee, to every state in this Union, a republican form of government, and shall protect each of them against invasion, and, on application of the legislature, or of the executive, when the legislature cannot be convened, against domestic violence. Article V. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention, for proposing amendments, which, in either case, shall be valid, to all intents and purposes, as part of this Constitution, when ratified by the legislature of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided, that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses, in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Article Vi. All debts contracted, and engagements entered into, before the adoption of this Constitution, shall be as valid against the United States under this Constitution, as under the Confederation. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state, shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office, or public trust, under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution, between the states so ratifying the same. Done in convention, by the unanimous consent of the states present, the 17th day of September, in the year of our Lord 1787, and of the independence of the United States of America the 12th. In witness whereof, we have hereunto subscribed our names. George Washington, President, and Deputy from Virginia. New Hampshire, John Langdon, Nicholas Gilman. Massachusetts, Nathaniel Gorham, Rufus King. Connecticut, William Samuel Johnson, Roger Sherman. New York, Alexander Hamilton. New Jersey, William Livingston, David Brearley, William Patterson, Jonathan Dayton. Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimons, Jared Ingersoll, James Wilson, Gouverneur Morris. Delaware, George Reed, Gunning Bedford, June John Dickinson, Richard Bassett, Jacob Broom. Maryland, James McHenry, Daniel of St. Thomas Jennifer, Daniel Carroll. Virginia, John Blair, James Madison, June. North Carolina, William Blount, Richard Dobbs Speight, Hugh Williamson. South Carolina, John Rutledge, Charles Coatsworth Pinckney, Charles Pinckney, Pierce Butler. Georgia, William Few, Abraham Baldwin. Attest, William Jackson, Secretary. In convention, Monday, September 17, 1787. Present, the states of New Hampshire, Massachusetts, Connecticut, Mr. Hamilton from New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Resolved, that the preceding Constitution be laid before the United States in Congress assembled, and that it is the opinion of this convention, that it should afterwards be submitted to a convention of delegates, chosen in each state by the people thereof, under the recommendation of its legislature, for their assent and ratification, and that each convention assenting to and ratifying the same, should give notice thereof to the United States in Congress assembled. Resolved, that it is the opinion of this convention, that as soon as the conventions of 9 states shall have ratified this Constitution, the United States in Congress assembled should fix a day on which electors should be appointed by the states which shall have ratified the same, and a day on which the electors should assemble to vote for the President, and the time and place for commencing proceedings under this Constitution, that after such publication the electors should be appointed, and the senators and representatives elected, that the electors should meet on the day fixed for the election of the President, and should transmit their votes, certified, signed, sealed and directed, as the Constitution requires, to the Secretary of the United States in Congress assembled, that the senators and representatives should convene at the time and place assigned, that the senators should appoint a President of the Senate, for the sole purpose of receiving, opening and counting the votes for President, and that, after he shall be chose, the Congress, together with the President, should without delay proceed to execute this Constitution. By the unanimous order of the Convention. George Washington, President. William Jackson, Secretary. In Convention, Sept. 17, 1787. Sir, we have now the honor to submit to the consideration of the United States in Congress and Congress assembled, that Constitution which has appeared to us the most advisable. The friends of our country have long seen and desired, that the power of making war, peace and treaties, that of levying money and regulating commerce, and the correspondent executive and judicial authorities, should be fully and effectually vested in the general government of the Union, but the impropriety of delegating such extensive trust to one body of men is evident. Hence results the necessity of a different organization. It is obviously impracticable, in the federal government of these states, to secure all rights of independent sovereignty to each, and yet provide for the interest and safety of all. Individuals entering into society must give up a share of liberty to preserve the rest. The magnitude of the sacrifice must depend as well on situation and circumstance, as on the object to be obtained. It is at all times difficult to draw with precision the line between those rights which must be surrendered, and those which may be reserved, and on the present occasion this difficulty was increased by a difference among the several states as to their situation, extent, habits and particular interests. In all our deliberations on this subject, we kept steadily in our view that which appears to us the greatest interest of every true American, the consolidation of our Union, in which are involved our prosperity, felicity, safety, perhaps our national existence. This important consideration, seriously and deeply impressed on our minds, led each state in the convention to be less rigid on points of inferior magnitude, than might have been otherwise expected, and thus the Constitution, which we now present, is the result of a spirit of amity, and of that mutual deference and concession which the peculiarity of our political situation rendered indispensable. That it will meet the full and entire approbation of every state is not perhaps to be expected, but each will doubtless consider, that had her interests been alone consulted, the consequences might have been particularly disagreeable or injurious to others, that it is liable to as few exceptions as could reasonably have been expected. We hope and believe, that it may promote the lasting welfare of that country so dear to us all, and secure her freedom and happiness, is our most ardent wish. With great respect, we have the honor to be, Sir, Your Excellency's most obedient and humble servants, George Washington, President. By unanimous order of the Convention. His Excellency the President of Congress. United States in Congress assembled. Friday, September 28, 1787. Present, New Hampshire, Massachusetts, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Virginia, North Carolina, South Carolina and Georgia, and from Maryland Mr. Ross. Congress having received the report of the convention lately assembled in Philadelphia. Resolved, unanimously, that the said report, with the resolutions and letter accompanying the same, be transmitted to the several legislatures, in order to be submitted to a convention of delegates, chosen in each state by the people thereof, in conformity to the resolves of the convention made and provided in that case. Charles Thompson, Secretary. State of Rhode Island and Providence Plantations. In General Assembly, October Session, 1787. It is voted and resolved, that the report of the convention, lately held at Philadelphia, proposing a new Constitution for the United States of America, be printed as soon as may be, that the following number of copies be sent to the several town clerks in the state, to be distributed among the inhabitants, that the freemen may have an opportunity of forming their sentiments of the said proposed Constitution, to wit, for Newport 10, Portsmouth 25, Middletown 15, New Shoreham 15, Jamestown 16, Tiverton 40, Little Compton 36, Providence 10, Smithfield 75, Scituate 55, Foster 55, Gloucester 60, Cumberland 40, Cranston 50, Johnston 30, North Providence 20, Westerly 31, North Kingstown 50, South Kingstown 100, Charlestown 25, Richmond 25, Exeter 31, Hopkinton 30, Bristol 20, Warren 10, Barrington 10, Warwick 56, East Greenwich 25, West Greenwich 22, and Coventry 30. A true copy. Witness, Henry Ward, Secretary. Providence, printed by John Carter. Exhibit C. The Bill of Rights Amendments to the Constitution. Article 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Article 2. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Article 3. No soldier shall, in time of peace be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Article 4. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Article 5. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service, in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled, in any criminal case, to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use without compensation. Article 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Article 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States, than according to the rules of the common law. Article 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Article 9. The enumeration in the Constitution, of certain rights, shall not be construed to deny or disparage others retained by the people. Article 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Article 11. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Article 12. 1. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. The person having the greatest number of votes for president, shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority. Then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. 2. The person having the greatest number of votes as vice president, shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. 3. But no person constitutionally ineligible to the office of president, shall be eligible to that of vice president of the United States. Article 13. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall incapable of holding any office of trust or profit under them, or either of them. Exhibit 3. Joint Resolution 20,110,202-04 Flag Act of 2011 Joint Resolution by Senate and House for Republic for the United States of America 2011. Grateful to Almighty God for our freedom, be it resolved, re-inhabited, reenacted and enacted, by Senate and House for Republic for the United States of America, Flag Act of 1777, Flag Act of 1794, Flag Act of 1818, and Flag Act of 2011 with its chain of absolute title, included herein by reference, attached. Act to establish the flag for the United States of America. Whereas the Flag Act of 1777 was passed by the Second Continental Congress on June 14, 1777, and reads in its entirety. Resolved, that the flag of the United States be made of 13 stripes, alternate red and white, that the Union be 13 stars, white in a blue field, representing a new constellation. And whereas the Flag Act of 1794 was signed into law by President George Washington on January 13, 1794, and reads in its entirety. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that from and after the first day of May, Anno Domini, 1795, the flag of the United States, be 15 stripes alternate red and white. That the Union be 15 stars, white in a blue field. And whereas the Flag Act of 1818 was enacted by Congress on April 4, 1818, and reads in its entirety. Be it enacted by the Senate and House of Representatives of the United States of America, in Congress assembled, that from and after the 4th day of July next, the flag of the United States be 13 horizontal stripes, alternate red and white, that the Union be 20 stars, white in a blue field. And be it further enacted, that on the admission of every new state into the Union, 1 star be added to the union of the flag, and that such addition shall take effect on the 4th day of July the next succeeding such admission. And whereas, with respect for Old Glory, the flag of the United States is and continues to be recognized around the world as standard for the Republic for the United States of America. And whereas the flag of the United States has called to the hearts of the men and women who have fought, and died, defending this nation and its people. And whereas the Municipal Corporation of the District of Columbia, doing business as United States, has misused the flag of the United States to represent its interests at the expense of this nation, its people, and particularly its defenders. And whereas we continue in peace and lawful reseating of the original Republic established circa 1791, Republic for the United States of America does stand apart from the United States. Therefore be it enacted by the Senate and House of Representatives for Republic for the United States of America, in Congress assembled that, from the date enacted, the flag for the United States of America be 13 stripes, alternate red and white, parallel to its fly, that it shows a square azure union, being at the top and left covering 8 stripes, that the union bears a constellation of 5 pointed white stars in number equal to the number of states in union, with each star orientation not consistent with a neighbor, all arranged in concentric circles centered, the middle forever open, and this flag is to be known as Forever Glory. And be it further enacted that on the admission of every new state into union, 1 star be added to the union of the flag, and that such addition shall take effect on the 4th day of July the next succeeding such admission. And be it further enacted that no fringe, attachment, or decoration is to be added to the flag. So help us Almighty God from this day 20 of December 2011 forward. Stars and Stripes chain of absolute title for all local people in union of the several free states, United States of America. Stars and Stripes / Flag Act of 1777. Star-Spangled Banner / Flag Act of 1794. Old Glory / Flag Act of 1818, and Forever Glory, Flag Act of 2011. All included by reference and attached. Republic for the United States of America. Legislation signature page. Flag Act 20,110,202-04. Brought to Congress for voting, December 20, 2011. Passed by Congress, December 30, 2011. Enacted into law, December 31, 2011. Passed by Senate, December 27, 2011. Witnessed and accepted for Senate. Senate President pro tempore. Passed by House, December 30, 2011. Witnessed and accepted for House of Representatives. Speaker of the House. Signed into law, December 31, 2011. Witnessed and accepted for Republic Chief Executive. President. Exhibit 4. 41st Congress. Sess. 3. Chew. 61,62. 1871. For expenses under the Neutrality Act, $20,000. For expenses incurred under instructions of the Secretary of State, of bringing home from foreign countries persons charged with crimes, and expenses incident thereto, including loss by exchange, $5,000. For relief and protection of American seamen in foreign countries, $100,000. For expenses which may be incurred in acknowledging the services of masters and crews of foreign vessels in rescuing American citizens from shipwreck, $5,000. For payment of the 7th annual installment of the proportion contributed by the United States toward the capitalization of the Scheldt dues, $55,584, and for such further sum, not exceeding $5,000, as may be necessary to carry out the stipulations of the treaty between the United States and Belgium. To pay to the Government of Great Britain and Ireland, the second and last installment of the amount awarded by the Commissioners under the Treaty of July 1, 1863, in satisfaction of the claims of the Hudson's Bay and of the Puget Sound Agricultural Company, $325,000 in gold coin, provided, that before payment shall be made of that portion of the above sum awarded to the Puget Sound Agricultural Company, all taxes legally assessed upon any of the property of said company covered by said award, before the same was made, and still unpaid, shall be extinguished by said Puget Sound Agricultural Company, or the amount of such taxes shall be withheld by the Government of the United States from the sum hereby appropriated. Approved, February 21, 1871. Chap. 62, an act to provide a government for the District of Columbia. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, all that of the territory of the United States included within the limits of the District of Columbia be, and the same is hereby, created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal, and exercise other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States and the provisions of this Act. Sec. 2. And be it further enacted, that the executive power and authority in and over said District of Columbia shall be vested in a governor, who shall be appointed by the President, by and with the advice and consent of the Senate, and who shall hold his office for 4 years, and until his successor shall be appointed and qualified. The governor shall be a citizen of and shall have resided within said district 12 months before his appointment, and have the qualifications of an elector. He may grant pardons and respites for offenses against the laws of said district enacted by the legislative assembly thereof. He shall commission all officers who shall be elected or appointed to office under the laws of the said district enacted as aforesaid, and shall take care that the laws be faithfully executed. Sec. 3. And be it further enacted, that every bill which shall have passed the Council and House of Delegates shall, before it becomes a law, be presented to the Governor of the District of Columbia. If he approve, he shall sign it, but if not, he shall return it, with his objections, to the House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If, after such reconsideration, 2/3 of all the members appointed or elected to the House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of all the members appointed or elected to that House, it shall become a law. But in all such cases the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the Governor within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the Legislative Assembly by their adjournment prevent its return, in which case it shall not be a law. Sec. 4. And be it further enacted, that there shall be appointed by the President, by and with the advice and consent of the Senate, a Secretary of said district, who shall reside therein and possess the qualification of an elector, and shall hold his office for 4 years, and until his successor shall be appointed and qualified, he shall record and preserve all laws and proceedings of the Legislative Assembly hereinafter constituted, and all the acts and proceedings of the Governor in his executive department. He shall transmit 1 copy of the JAWS and journals of the Legislative Assembly within 30 days after the end of each session, and 1 copy of the executive proceedings and official correspondence semi-annually, on the first days of January and July in each year, to the President of the United States, and 4 copies of the laws to the President of the Senate and to the Speaker of the House of Representatives, for the use of Congress, and in case of the death, removal, resignation, disability, or absence of the Governor from the district, the Secretary shall be, and he is hereby, authorized and required to execute and perform all the powers and duties of the Governor during such vacancy, disability, or absence, or until another Governor shall be duly appointed and qualified to fill such vacancy. And in case the offices of Governor and Secretary shall both become vacant, the powers, duties, and emoluments of the office of Governor shall devolve upon the presiding officer of the Council, and in case that office shall also be vacant, upon the presiding officer of the House of Delegates, until the office shall be filled by a new appointment. Sec. 5. And be it further enacted, that legislative power and authority in said district shall be vested in a legislative assembly as hereinafter provided. The assembly shall consist of a council and House of Delegates. The council shall consist of 11 members, of whom 2 shall be residents of the city of Georgetown, and 2 residents of the county outside of the cities of Washington and Georgetown, who shall be appointed by the President, by and with the advice and consent of the Senate, who shall have the qualification of voters as hereinafter prescribed, 5 of whom shall be first appointed for the term of 1 year, and 6 for the period of 2 years, provided that all subsequent appointments shall be for the term of 2 years. The House of Delegates shall consist of 22 members, possessing the same qualifications as prescribed for the members of the Council, whose term of service shall continue 1 year. An apportionment shall be made, as nearly equal as practicable, into 11 districts for the appointment of the Council, and into 22 districts for the election of delegates, giving to each section of the district representation in the ratio of its population as nearly as may be. And the members of the Council and of the House of Delegates reside in and be inhabitants of the districts from which they are appointed or elected, respectively. For the purposes of the first election to be held under this Act, the Governor and judges of the Supreme Court of the District of Columbia shall designate the districts for members. Of the House of Delegates, appoint a board of registration and persons to superintend the election and the returns thereof, prescribe the time, places, and manner of conducting such election, and make all needful rules and regulations for carrying into effect the provisions of this Act not otherwise herein provided for, provided, that the first election shall be held within 60 days from the passage of this Act. In the first and all subsequent elections the persons having the highest number of legal votes for the House of Delegates, respectively, shall be declared by the Governor duly elected members of said House. In case 2 or more persons voted for shall have an equal number of votes for the same office, or if a vacancy shall occur in the House of Delegates, the Governor shall order a new election. And the persons thus appointed and elected to the Legislative Assembly shall meet at such time and at such place within the district as the Governor shall appoint, but thereafter the time, place, and manner of holding and conducting all elections by the people, and the formation of the districts for members of the Council and House of Delegates, shall be prescribed by law, as well as the day of the commencement of the regular sessions of the Legislative Assembly, provided, that no session in any 1 year shall exceed the term of 60 days, except the first session, which may continue 100 days. Sec. 6. And be it further enacted, that the Legislative Assembly shall have power to divide that portion of the district not included in the corporate limits of Washington or Georgetown into townships, not exceeding 3, and create township officers, and prescribe the duties thereof, but all township officers shall be elected by the people of the townships respectively. Sec. 7. And be it further enacted, that all male citizens of the United States, above the age of 21 years, who shall have been actual residents of said district for 3 months prior to the passage of this Act, except such as are non compos mentis and persons convicted of infamous crimes, shall be entitled to vote at said election, in the election district or precinct in which he shall then reside, and shall have so resided for 30 days immediately preceding said election, and shall be eligible to any office within the said district, and for all subsequent elections 12 months prior residence shall be required to constitute a voter, but the Legislative Assembly shall have no right to abridge or limit the right of suffrage. Sec. 8. And be it further enacted, that no person who has been or hereafter shall be convicted of bribery, perjury, or other infamous crime, nor any person who has been or may be a collector or holder of public moneys who shall not have accounted for and paid over, upon final judgment duly recovered according to law, all such monies due from him, shall be eligible to the Legislative Assembly or to any office of profit or trust in said district. Sec. 9. And be it further enacted, that members of the Legislative Assembly, before they enter upon their official duties, shall take and subscribe the following oath or affirmation: I do solemnly swear, or affirm, that I will support the Constitution of the United States, and will faithfully discharge the duties of the office upon which I am about to enter, and that I have not knowingly or intentionally paid or contributed anything, or made any promise in the nature of bribe, to directly or indirectly influence any vote at the election at which I was chosen to fill the said office, and have not accepted, nor will I accept, or receive, directly or indirectly, any money or other valuable thing for any vote or influence that I may give or withhold on any bill, resolution, or appropriation, or for any other official act. Any member who shall refuse to take the oath herein prescribed shall forfeit his office, and every son who shall be convicted of having sworn falsely to or of violating his said oath shall forfeit his office, be disqualified thereafter from holding any office of profit or trust in said district, and shall be deemed guilty of perjury, and upon conviction shall be punished accordingly. Sec. 10. And be it further enacted, that a majority of the legislative assembly appointed or elected to each house shall constitute a quorum. The House of Delegates shall be the judge of the election returns and qualifications of its members. Each house shall determine the rules of its proceedings, and shall choose its own officers. The governor shall call the council to order at the opening of each new assembly, and the secretary of the district shall call the House of Delegates to order at the opening of each new legislative assembly, and shall preside over it until a temporary presiding officer shall have been chosen and shall have taken his seat. No member shall be expelled by either house except by a vote of 2/3 of all the members appointed or elected to that house. Each house may punish by imprisonment any person not a member who shall be guilty of disrespect to the house by disorderly or contemptuous behavior in its presence, but no such imprisonment shall extend beyond 24 hours at one time. Neither house shall, without the consent of the other, adjourn for more than 2 days, or to any other place than that in which such house shall be sitting. At the request of any member the yeas and nays shall be taken upon any question and entered upon the journal. Sec. 11. And be it enacted, that bills may originate in either house, but may be altered, amended, or rejected by the other, and on the final passage of all bills the vote shall be by yeas and nays upon each bill separately, and shall be entered upon the journal, and no bill shall become a law without the concurrence of a majority of the members elected to each house. Sec. 12. And be it further enacted, that every bill shall be read at large on 3 different days in each house. No act shall embrace more than one subject, and that shall be expressed in its title, but if any subject shall be embraced in an act which shall not be expressed in the title, such act shall be void only as to so much thereof as shall not be expressed in the title, and no act of the legislative assembly shall take effect until 30 days after its passage, unless, in case of emergency, which emergency shall be expressed in the preamble or body of the act, the legislative assembly shall by a vote of 2/3 of all the members appointed or elected to each house otherwise direct. Sec. 18. And be it further enacted, that no money shall be drawn from the treasury of the district, except in pursuance of an appropriation made by law, and no bill making appropriations for the pay or salaries of the officers of the district government shall contain any provisions on any other subject. Sec. 14. And be it enacted, that each legislative assembly shall provide for all appropriations necessary for the ordinary and contingent expenses of the government of the district until the expiration of the first fiscal quarter after the adjournment of the next regular session, the aggregate amount of which shall not be increased without a vote of 2/3 of the members elected or appointed to each house as herein provided, nor exceed the amount of revenue authorized by law to be raised in such time, and all appropriations, general of special, requiring money to be paid out of the district treasury, from funds belonging to the district, shall end with such fiscal quarter, and no debt, by which the aggregate debt of the district shall exceed 5% of the assessed property of the district, shall be contracted, unless the law authorizing the same shall at a general election have been submitted to the people and have received a majority of the votes cast for members of the legislative assembly at such election. The legislative assembly shall provide for the publication of said law in at least 2 newspapers in the district for 3 months, at least, before the vote of the people shall be taken on the same, and provision shall be made in the act for the payment of the interest annually, as it shall accrue, by a tax levied for the purpose, or from other sources of revenue, which law providing for the payment of such interest by such tax shall be irrepealable until such debt be paid, provided, that the law levying the tax shall be submitted to the people with the law authorizing the debt to be contracted. Sec. 15. And be it further enacted, that the legislative assembly shall never grant or authorize extra compensation, fee, or allowance to any public officer, agent, servant, or contractor, after service has been rendered or a contract made, nor authorize the payment of any claim, or part thereof, hereafter created against the district under any contract or agreement made, without express authority of law, and all such unauthorized agreements or contracts shall be null and void. Sec. 16. And be it further enacted, that the district shall never pay, assume, or become responsible for the debts or liabilities of, or in any manner give, loan, or extend its credit to or in aid of any public or other corporation, association, or individual. Sec. 17. And be it further enacted, that the legislative assembly shall not pass special laws in any of the following cases, that is to say, for granting divorces, regulating the practice in courts of justice, regulating the jurisdiction or duties of justices of the peace, police magistrates, or constables, providing for changes of venue in civil or criminal cases, or swearing and impaneling jurors, remitting fines, penalties, or forfeitures, the sale or mortgage of real estate belonging to minors or others under disability, changing the law of descent, increasing or decreasing the fees of public officers during the term for which said officers are elected or appointed, granting to any corporation, association, or individual, any special or exclusive privilege, immunity, or franchise whatsoever. The Legislative Assembly shall have no power to release or extinguish, in whole or in part, the indebtedness, liability, or obligation of any corporation or individual to the district or to any municipal corporation therein, nor shall the Legislative Assembly have power to establish any bank of circulation, nor to authorize any company or individual to issue notes for circulation as money or currency. Sec. 18. And be it further enacted, that the legislative power of the district shall extend to all rightful subjects of legislation within said district, consistent with the Constitution of the United States and the provisions of this Act, subject, nevertheless, to all the restrictions and limitations imposed upon states by the 10th section of the first article of the Constitution of the United States, but all acts of the Legislative Assembly shall at all times be subject to repeal or modification by the Congress of the United States, and nothing herein shall be construed to deprive Congress of the power of legislation over said district in as ample manner as if this law had not been enacted. Sec. 19. And be it further enacted, that no member of the Legislative Assembly shall hold or be appointed to any office, which shall have been created or the salary or emoluments of which shall have been increased while he was a member, during the term for which he was appointed or elected, and for 1 year after the expiration of such term, and no person holding any office of trust or profit under the government of the United States shall be a member of the Legislative Assembly. Sec. 20. And be it further enacted, that the said Legislative Assembly shall not have power to pass any ex post facto law, nor law impairing the obligation of contracts, nor to tax the property of the United States, nor to tax the lands or other property of non-residents higher than the lands or other property of residents, nor shall lands or other property in said district be liable to a higher tax, in any 1 year, for all general objects, territorial and municipal, than $2 on every $100 of the cash value thereof, but special taxes may be levied in particular sections, wards, or districts for their particular local improvements, nor shall said territorial government have power to borrow money or issue stock or bonds for any object whatever, unless specially authorized by an act of the Legislative Assembly, passed by a vote of 2/3 of the entire number of the members of each branch thereof, but said debt in no case to exceed 5% of the assessed value of the property of said district, unless authorized by a vote of the people, as hereinbefore, provided. Sec. 21. And be it further enacted, that the property of that portion of the district not included in the corporations of Washington or Georgetown shall not be taxed for the purposes either of improving the streets, alleys, public squares, or other public property of the said cities, or either of them, nor for any other expenditure of a local nature, for the exclusive benefit of said cities, or either of them, nor for the payment of any debt heretofore contracted, or that may hereafter be contracted by either of said cities while remaining under a municipal government not coextensive with the district. Sec. 22. And be it further enacted, that the property within the corporate limits of Georgetown shall not be taxed for the payment of any debt heretofore or hereafter to be contracted by the Corporation of Washington, nor shall the property within the corporate limits of Washington be taxed for the payment of any debt heretofore or hereafter to be contracted by the Corporation of Georgetown, and so long as said cities shall remain under distinct municipal governments, the property within the corporate limits of either of said cities shall not be taxed for the local benefit of the other, nor shall said cities, or either of them, be taxed for the exclusive benefit of the county outside of the limits thereof, provided, that the Legislative Assembly may make appropriations for the repair of roads, or for the construction or repair of bridges outside the limits of said cities. Sec. 28. And be it further enacted, that it shall be the duty of said Legislative Assembly to maintain a system of free schools for the education of the youth of said district, and all monies raised by general taxation or arising from donations by Congress, or from other sources, except by bequest or devise, for school purposes, shall be appropriated for the equal benefit of all the youths of said district between certain ages, to be defined by law. Sec. 24. And be it further enacted, that the said Legislative Assembly shall have power to provide for the appointment of as many justices of the peace and notaries public for said district as may be deemed necessary, to define their jurisdiction and prescribe their duties, But justices of the peace shall not have jurisdiction of any controversy in which the title of land may be in dispute, or in which the debt or some claim shall exceed $100, provided, however, that all justices of the peace and notaries public now in commission shall continue in office till their present commissions expire, unless sooner removed pursuant to existing laws. Sec. 25. And be it further enacted, that the judicial courts of said district shall remain as now organized until abolished or changed by act of Congress, but such legislative assembly shall have power to pass laws modifying the practice thereof, and conferring such additional jurisdiction as may be necessary to the due execution and enforcement of the laws of said district. Sec. 26. And be it further enacted, that there shall be appointed by the President of the United States, by and with the advice and consent of the Senate, a Board of Health for said district, to consist of fire persons, whose duty it shall be to declare what shall be deemed nuisances injurious to health, and to provide for the removal thereof, to make and enforce regulations to prevent domestic animals from running at large in the cities of Washington and Georgetown, to prevent the sale of unwholesome food in said cities, and to perform such other duties as shall be imposed upon said board by the Legislative Assembly. Sec. 27. And be it further enacted, that the offices and duties of Register of Wills, Recorder of Deeds, United States Attorney, and United States Marshal for said district shall remain as under existing laws till modified by act of Congress, but said Legislative Assembly shall have power to impose such additional duties upon said officers, respectively, as may be necessary to the due enforcement of the laws of said district. Sec. 28. Be it further enacted, that the said Legislative Assembly shall have power to create by general law, modify, repeal, or amend, within said district, corporations aggregate for religious, charitable, educational, industrial, or commercial purposes, and to define their powers and liabilities, provided, that the powers of corporations so created shall be limited to the District of Columbia. Sec. 29. And be it further enacted, that the Legislative Assembly shall define by law who shall be entitled to relief as paupers in said district, and shall provide by law for the support and maintenance of such paupers, and for that purpose shall raise the money necessary by taxation. Sec. 30. And be it further enacted, that the Legislative Assembly shall have power to provide by law for the election or appointment of such ministerial officers as may be deemed necessary to carry into effect the laws of said district, to prescribe their duties, their terms of office, and the rate and manner of their compensation. Sec. 31. And be it further enacted, that the Governor, Secretary, and other officers to be appointed pursuant to this Act, shall, before they act as such, respectively, take and subscribe an oath or affirmation before a judge of the Supreme Court of the District of Columbia, or some justice of the peace in the limits of said district, duly authorized to administer oaths or affirmations by the laws now in force therein, or before the Chief Justice or some Associate Justice of the Supreme Court of the United States, to support the Constitution of the United States, and faithfully to discharge the duties of their respective offices, which said oaths, when so taken, shall be certified by the person before whom the same shall have been taken, and such certificates shall be received and recorded by the said Secretary among the executive proceedings, and all civil officers in said district, before they act as such, shall take and subscribe a like oath or affirmation before the said Governor or Secretary, or some judge or justice of the peace of the district, who may be duly commissioned and qualified, or before the Chief Justice of the Supreme Court of the United States, which said oath or affirmation shall be certified and transmitted by the person administering the same to the Secretary, to be by him recorded as aforesaid, and afterward the like oath or affirmation shall be taken and subscribed, certified and recorded in such manner and form as may be prescribed by law. Sec. 32. And be it further enacted, that the Governor shall receive an annual salary of $3,000, and the Secretary shall receive an annual salary of $2,000, and that the said salaries shall be paid quarter-yearly, from the dates of the respective appointments, at the Treasury of the United States, but no payment shall be made until said officers shall have entered upon the duties of their respective appointments. The members of the Legislative Assembly shall be entitled to receive $4 each per day during their actual attendance at the session thereof, and an additional allowance of $4 per day shall be paid to the presiding officer of each house for each day he shall so preside. And at Chief Clerk, 1 Assistant Clerk, 1 Engrossing and 1 Enrolling Clerk, and a Sergeant at Arms may be chosen for each house, and the Chief Clerk shall receive $4 per day, and the said other officers $3 per day, during the session of the Legislative Assembly, provided, that there shall be but one session of the Legislative Assembly annually, unless, on an extraordinary occasion, the Governor shall think proper to call the Legislative Assembly together. And the Governor and Secretary of the District shall, in the disbursement of all monies appropriated by Congress and entrusted to them, be governed solely by the instructions of the Secretary of the Treasury of the United States, and shall semi-annually account to the said Secretary for the manner in which the aforesaid monies shall have been expended, and no expenditure shall be made by the said Legislative Assembly of funds appropriated by Congress, for objects not especially authorized, by acts of Congress making the appropriations, nor beyond the sums thus appropriated for such objects. Sec. 33. And be it further enacted, that the Legislative Assembly of the District of Columbia shall hold its first session at such time and place in said district as the governor thereof shall appoint and direct. Sec. 34. And be it further enacted, that a delegate to the House of Representatives of the United States, to serve for the term of 2 years, who shall be a citizen of the United States and of the District of Columbia, and shall have the qualifications of a voter, may be elected by the voters qualified to elect members of the Legislative Assembly, who shall be entitled to the same rights and privileges as are exercised and enjoyed by the delegates from the several territories of the United States to the House of Representatives, and shall also be a member of the Committee for the District of Columbia, but the delegate first elected shall hold his seat only during the term of the Congress to which he shall be elected. The first election shall be held at the time and places and be conducted in such manner as the elections for members of the House of Representatives are conducted, and at all subsequent elections the time and places and the manner of holding the elections shall be prescribed by law. The person having the greatest number of legal votes shall be declared by the governor to be duly elected, and a certificate thereof shall he given accordingly, and the Constitution and all the laws of the United States, which are not locally inapplicable, shall have the same force and effect within the said District of Columbia as elsewhere within the United States. Sec. 35. And be it further enacted, that all officers to be appointed by the President of the United States, by and with the advice and consent of the Senate, for the District of Columbia, who, by virtue of the provisions of any law now existing, or which may be enacted by Congress, are required to give security for monies that may be entrusted to them for disbursement, shall give such security at such time and in such manner as the Secretary of the Treasury may prescribe. Sec. 36. And be it further enacted, that there shall be a valuation taken in the District of Columbia of all real estate belonging to the United States in said district, except the public buildings, and the grounds which have been dedicated to the public use as parks and squares, at least once in 5 years, and return thereof shall be made by the Governor to the President of the Senate and Speaker of the House of Representatives on the first day of the session of Congress held after such valuation shall be taken, and the aggregate of the valuation of private property in said district, whenever made by the authority of the Legislative Assembly, shall be reported to Congress by the Governor, provided, that all valuations of property belonging to the United States shall be made by such persons as the Secretary of the Interior shall appoint, and under such regulations as he shall prescribe. Sec. 37. And be it further enacted, that there shall be in the District of Columbia a Board of Public Works, to consist of the Governor, who shall be President of said Board, 4 persons, to be appointed by the President of the United States, by and with the advice and consent of the Senate, one of whom shall be a civil engineer, and the others citizens and residents of the district, having the qualifications of an elector therein. One of said board shall be a citizen and resident of Georgetown, and one of said board shall be a citizen and resident of the county outside of the cities of Washington and Georgetown. They shall hold office for the term of 4 years, unless sooner removed by the President of the United States. The Board of Public Works shall have entire control of and make all regulations which they shall deem necessary for keeping in repair the streets, avenues, alleys, and sewers of the city, and other works which may be entrusted to their charge by the Legislative Assembly or Congress. They shall disburse upon their warrant all monies appropriated by the United States, or the District of Columbia, or collected from property holders, in pursuance of law, for the improvement of streets, avenues, alleys, and sewers, and roads and bridges, and shall assess in such manner as shall be prescribed by law, upon the property adjoining and to be specially benefited by the improvements authorized by law and made by them, a reasonable proportion of the cost of the improvement, not exceeding 1/3 of such cost, which sum shall be collected as all other taxes are collected. They shall make all necessary regulations respecting the construction of private buildings in the District of Columbia, subject to the supervision of the Legislative Assembly. All contracts made by the said Board of Public Works shall be in writing, and shall be signed by the parties making the same, and a copy thereof shall be filed in the office of the Secretary of the District, and said Board of Public Works shall have no power to make contracts to bind said district to the payment of any sums of money except in pursuance of appropriations made by law, and not until such appropriations shall have been made. All contracts made by said board in which any member of said board shall be personally interested shall be void, and no payment shall be made thereon by said district or any officers thereof. On or before the first Monday in November of each year, they shall submit to each branch of the Legislative Assembly a report of their transactions during the preceding year, and also furnish duplicates of the same to the Governor, to be by him laid before the President of the United States for transmission. Sent the two Houses of Congress, and shall be paid the sum of $2,500 each annually. Sec. 38. And be it further enacted, that the officers herein provided for, who shall be appointed by the President, by and with the advice and consent of the Senate, shall be paid by the United States by appropriations to be made by law as hereinbefore provided, and all other officers of said district provided for by this act shall be paid by the district, provided, that no salary shall be paid to the Governor as a member of the Board of Public Works in addition to his salary as Governor, nor shall any officer of the Army appointed upon the Board of Public Works receive any increase of pay for such service. SRO 39. And be it further enacted, that if, at any election hereafter held in the District of Columbia, any person shall knowingly personate and vote, or attempt to vote, in the name of any other person, whether living, dead, or fictitious, or vote more than once at the same election for any candidate for the same office, or vote at a place where he may not be entitled to vote, or vote without having a lawful right to vote, or do any unlawful act to secure a right or opportunity to vote for himself or any other person, or by force, threats, menace, or intimidation, bribery, reward, or offer, or promise thereof, or otherwise unlawfully prevent any qualified voter of the District of Columbia from freely exercising the right of suffrage, or by any such means induce any voter to refuse to exercise such right, or compel or induce, by any such means or otherwise, any officer of any election in said district to receive a vote from a person not legally qualified or entitled to vote, or interfere in any manner with any officer of said elections in the discharge of his duties, or by any unlawful means induce any officer of an election, or officer whose duty it is to ascertain, announce, or declare the result of any such election, or give or make any certificate, document, or evidence in relation thereto, to violate or refuse to comply with his duty, or any law regulating the same, or knowingly and willfully receive the vote of any person not entitled to vote, or refuse to receive the vote of any person entitled to vote, or aid counsel, procure, or advise any such voter, person, or officer to do an act hereby made a crime, or to omit to do any duty the omission of which is hereby made a crime, or attempt to do so, every such person shall be deemed guilty of a crime, and shall for such crime be liable to prosecution in any court of the United States of competent jurisdiction, and on conviction thereof shall be punished by a fine not exceeding $500, or by imprisonment for a term not exceeding 3 years, or both, in the discretion of the court, and shall pay the costs of prosecution. Sec. 40. And be it further enacted, that the charters of the cities of Washington and Georgetown shall be repealed on and after the first day of June, A.D. 1871, and all offices of said corporations abolished at that date. The levy court of the District of Columbia and all offices connected therewith shall be abolished on and after said first day of June, A.D. 1871, but all laws and ordinances of said cities, respectively, and of said levy court, not inconsistent with this act, shall remain in full force until modified or repealed by Congress or the Legislative Assembly of said district. That portion of said district included within the present limits of the City of Washington shall continue to be known as the City of Washington, and that portion of said district included within the limits of the City of Georgetown shall continue to be known as the City of Georgetown, and the Legislative Assembly shall have power to levy a special tax upon property, except the property of the Government of the United States, within the City of Washington for the payment of the debts of said city, and upon property, except the property of the Government of the United States, within the limits of the City of Georgetown for the payment of the debts of said city, and upon property, except the property of the Government of the United States, within said district not included within the limits of either of said cities to pay any debts owing by that portion of said district, provided, that the charters of said cities severally, and the powers of said levy court, shall be continued for the following purposes, to wit, for the collection of all sums of money due to said cities, respectively, or to said levy court, for the enforcement of all contracts made by said cities, respectively, or by said levy court, and all taxes, heretofore assessed, remaining unpaid, for the collection of all just claims against said cities, respectively, or against said levy court, for the enforcement of all legal contracts against said cities, respectively, or against said levy court, until the affairs of said cities, respectively, and of said levy court, shall have been fully closed, and no suit in favor of or against said corporations, or either of them, shall abate by reason of the passage of this act. The same shall be prosecuted to final judgment as if this act had not been passed. Sec. 41. And be it further enacted, that there shall be no election holden for mayor or members of the Common Council of the City of Georgetown prior to the 1st day of June, 1871, but the present mayor Common Council of said city shall hold their offices until said 1st day of June next. No taxes for general purposes shall hereafter be assessed by the municipal authorities of the cities of Washington or Georgetown, or by said levy court. And upon the repeal of the charters of the cities of Washington and Georgetown, the District of Columbia be, and is hereby, declared to be the successor of said corporations, and all the property of said corporations, and of the County of Washington, shall become vested in the said District of Columbia, and all fines, penalties, costs, and forfeitures, which are now by law made payable to said cities, respectively, or said levy court, shall be paid to said District of Columbia, and the salaries of the judge and clerk of the police court, the compensation of the deputy clerk and bailiffs of said police court, and of the marshal of the District of Columbia shall be paid by said district, provided that the monies collected upon the judgments of said police court, or so much thereof as may be necessary, shall be applied to the payment of the salaries of the judge and other officers of said court, and to the payment of the necessary expenses thereof, and any surplus remaining after paying the salaries, commission, and expenses aforesaid, shall be paid into the treasury of the district at the end of every quarter. Approved, February 21, 1871. Chap. Shall. An act to the times for holding the district and circuit courts of the United States at Erie, Pennsylvania. Be it enacted by the Senate and House of Ives of the United States of America and Congress assembled, that from and after this date the July terms of the district and circuit courts of the United States in and for the Western District of Pennsylvania, at Erie, shall be commenced and held on and after the third Monday of July in each year, and the January terms of said court at the same place shall be commenced and held at Erie, Pennsylvania, on and after the second Monday in January of each year. Approved, February 21, 1871. Chap. 64, an act to provide for the apportionment of the members of the Legislative Assembly of the Territory of Colorado. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that it shall be the duty of the Governor, Chief Justice, and United States Attorney for the Territory of Colorado, on or before the 1st day of June next, to make an apportionment of the members of the Council and House of Representatives of the said territory, among the several districts, for the election of members of the Council and House of Representatives, giving to each section of the territory representation in ratio of its population, as near as may be, as ascertained by the census taken by authority of the United States in the year 1870. Sec. 2. And be it further enacted, that it shall be the duty of said Governor, Chief Justice, and United States Attorney to make an official certificate showing the number of members of the Council and House of Representatives the several districts of said territory are entitled to, as apportioned under the provisions of this Act, and file said certificate in the office of the Secretary of said territory, on or before the 1st day of July next, and said apportionment so made shall be held to be the proper and legal apportionment for the members of the next Legislative Assembly of the Territory of Colorado. Approved, February 21, 1871. Chap. 65. An act to repeal an act of the Legislative of Wyoming Territory apportioning said territory for members of the Council of House of Representatives of the Territorial Legislature. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, the act of the Legislature of the Territory of Wyoming, entitled an Act Apportioning. Exhibit 5-2A Atlantic Charter. The President of the United States of America and the Prime Minister, Mr. Churchill, representing His Majesty's government in the United Kingdom, being met together, deem it right to make known certain common principles in the national policies of their respective countries on which they base their hopes for a better future for the world. 1. Their countries seek no aggrandizement, territorial or other. 2. They desire to see no territorial changes that do not accord with the freely expressed wishes of the peoples concerned. 3. They respect the right of all peoples to choose the form of government under which they will live, and they wish to see sovereign rights and self-government restored to those who have been forcibly deprived of them. 4. They will endeavor, with due respect for their existing obligations, to further the enjoyment by all states, great or small, victor or vanquished, of access, on equal terms, to the trade and to the raw materials of the world which are needed for their economic prosperity. 5. They desire to bring about the fullest collaboration between all nations in the economic field with the object of securing, for all, improved labor standards, economic advancement and social security. 6. After the final destruction of the Nazi tyranny, they hope to see established a peace which will afford to all nations the means of dwelling in safety within their own boundaries, and which will afford assurance that all the men in all the lands may live out their lives in freedom from fear and want. 7. Such a peace should enable all men to traverse the high seas and oceans without hindrance. 8. They believe that all of the nations of the world, for realistic as well as spiritual reasons, must come to the abandonment of the use of force. Since no future peace can be maintained if land, sea or air armaments continue to be employed by nations which threaten, or may threaten, aggression outside of their frontiers, they believe, pending the establishment of a wider and permanent system of general security, that the disarmament of such nations is essential. They will likewise aid and encourage all other practicable measures which will lighten for peace-loving peoples the crushing burden of armaments. Franklin D. Roosevelt. Winston S. Churchill. August 14, 1941. The following statements by each Free State Republic representatives were signed for each individual state in the Republic for the United States of America. State Acknowledgement and Affirmation of Anion, circa 2011. We the people on Free State Republic, a free and independent state, establish and continue a republican form of governance guaranteed by United States Constitution circa 1789 and Bill of Rights circa 1791, and we the people on Free State Republic hereby acknowledge and affirm that we are in union with people on other free and independent states comprising Republic for the United States of America, and by manifest will and mutual agreement of we the people on this free and independent state, we enjoy and lawfully protect our God-given unalienable rights of life, liberty, and the pursuit of happiness, and we the people on Free State Republic uphold constitutional laws, lawful treaties and lawful contracts, and enforcement thereof for this free and independent state in union for Republic for the United States of America, and we the people hold that all officials, elected or appointed, for Republic for the United States of America, agree to protect the God-given unalienable rights endowed to the people and to honor and protect the freedom and independence of states in union at all times in accord with Declaration of Independence circa 1776, Constitution circa 1789, Bill of Rights circa 1791, and a republican form of governance, at all levels, shall be recognized, adhered to, and preserved. Autograph for State Legislative Branch. Autograph for State Executive Branch. Autograph for State Judicial Branch.